Ms. Kimberly, are you ready back there? For the audience's information, this full meeting will be recorded, and you can watch yourself on YouTube at some point if you really want to watch this, go through this process a second time. All right, at this time, if you don't mind turning your cell phones off or down to silent, put Words with Friends up, Facebook, whatever it is, Instagram, and pay attention. We'd appreciate it. The good news is, from those of you who are supposed to be here for a full commission meeting, we will get done today. We do not have a session tomorrow, so you had the chance to be here for 2 days, and you're welcome to come back tomorrow, but we won't be here, all right? But with that said, there's no promise on how long this meeting will take today. The good news is, from your perspective, as this commission typically has 9 members, today we'll have 5. And so surely to goodness there'll be 3 to 4 less people talking on different issues, which ought to facilitate this meeting, I hope. Ms. Maxwell, our executive director, will call the roll.
This meeting's date, time, and location have been noticed on the Tennessee Real Estate Commission's website, included as a part of this year's meeting calendar since August the 12th of 2014. Additionally, the agenda for this month's meeting has been posted on the Tennessee Real Estate Commission's website since Friday, March 27th, 2015, and the meeting has been noticed on the 10.gov website since Friday, March 27th, 2015. Now I'll call the roll. Grease?
Here.
DeChara?
Here.
Alexander? Absent. Bloom?
Here.
Collins, absent. Franks?
Here.
Hills, absent. McMullen?
Here.
So we have a quorum, we have 5.
Thank you. At this time, I'm going to ask Commissioner Bloom to lead us in an invocation, and then if you will stand, we'll have a pledge to the flag. Commissioner Bloom.
Father, we recognize we're a blessed people living in a blessed country, and we are involved in a blessed profession, and we give you thanks for that. Help us to make decisions that are wise, that affect positively our profession and the people who are involved, and this is our prayer in the name of Jesus. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Commissioner. Next on the agenda is to adopt the agenda.
Motion to approve.
We do have a couple changes, yeah.
Okay, I have a motion to approve the agenda by Commissioner DeChara. Is there a second?
Second.
Second by Commissioner Franks. Now, Ms. Kropp, do you want to?
We do have one informal appearance that is on your agenda that's not going to be able to make it today.
Which one is
Ms.
that?
Chambers, that was on the agenda that was posted on the website.
So how many informals does
There,
that?
we have two that are
Two.
going to be coming in today, and
Okay.
they're both listed on there, so there's no additions with that regard. And also, I believe since Commissioner Hills is not here, the discussion about principal brokers working but not residing in Tennessee, I believe Ms. Maxwell is going to defer that matter to next month if you all wanted to do that, so that Commissioner Hills could be here to participate in that discussion. Also, we have an informal applicant appearance for a reinstatement, Mr. Wallace McClure, that's going to be in addition to the agenda that was posted on the website last week. And there are a few additional matters to the legal report that were not originally listed at the time of publication, and there's an additional list at the back of the room of those case numbers if anybody's interested. It's going to be included in the report, though.
So, Mr. DeChara, Ms. Franks, with those additions and deletions, are you okay with your motion?
Yes. Yes.
All right, the motion's to approve the agenda as modified by Counsel Julie Kropp. Is there discussion on the motion? Let's vote. Those in favor of the motion vote aye. Aye. Those opposed, no. That motion passes unanimously. Next up is approval of last month's meeting's minutes. Is there a motion?
So moved.
Motion by Commissioner Franks.
Second.
Seconded by Commissioner DeChara that last month's minutes be approved as submitted to us and reviewed by us. Discussion. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. All right. Is Jeffrey King here? All right. I know we're ahead of schedule, but if you guys are ready, if you two will come up and find 2 chairs where you can share a microphone. Say the last 2 chairs over there would be great. All right, Ms. Maxwell, you want to let the audience and this commission know what's up with these 2 guys?
Yes, this is a request for a waiver of what we call the 50-mile rule, which is actually Rule 1260-2-.012, which states that a licensee cannot live more than 50 miles from their firm office. And Mr. Finn currently resides in Carlsbad, California, and the office of the firm with which he wishes to affiliate is located in Memphis. That's a distance of 1,564 miles as the crow flies, which is what the rule provides, the distance as the crow flies. And a little background information, Jeffrey Marshall King, license number 325758, is the principal broker of Meridian Property Management, LLC, which holds Tennessee firm license 262242, and Meridian National Realty, LLC, which holds Tennessee firm license 262293. Both firms are physically located at 2760 Colony Park Drive in Memphis, Tennessee, 38118. Mr. King also holds a California broker license number 1206504. Michael Charles Finn is currently not licensed in Tennessee. Mr. Finn took and passed the state and national exams and applied for an affiliate broker license in July of 2014. At that time, Mr. Finn could not be licensed because his residence in California was more than 50 miles from his proposed firm office of Meridian National Realty, LLC, and because he had not completed the 30-hour course for new affiliates. The California real estate record indicate that there was a Michael Charles Finn licensed as a salesperson in California from 5/11/2010 to 5/10 of 2014, at which time the license number 1882446 expired. Mr. Finn did not apply for his Tennessee affiliate broker license by license recognition, and I'm not positive that those are his correct records in California, but it was a Michael Charles Finn that was listed. Mr. Finn would like to affiliate with Mr. King's firm, Meridian National Realty, LLC, located in Memphis. Mr. Finn's application lists his residence as Navarra Drive, Carlsbad, California, which is approximately 1,565 miles as the crow flies from the Memphis office. The commissioners had a map attached that showed the as the crow flies distance. Mr. King is principal broker of Meridian Property, LLC, and Meridian National Realty, LLC, is, as I mentioned, requesting a waiver of the 50-mile rule so that Mr. Finn can affiliate with one of his companies. Jeffrey Marshall King was first licensed as a broker in Tennessee on 11/1 of 2012 through the license recognition process. Mr. King holds an active California broker license with a current expiration date of 8/3 of 2016. The California records indicate that Mr. King was first licensed as a salesperson in California on 2/22/1996 and was issued a broker license in California on 8/4 of 2008. Mr. King was co-founder of Meridian Pacific Properties, Inc., and has been an active investor in real estate in California, Mississippi, and Tennessee. Mr. King became the principal broker of Meridian Property Management, LLC, when it was first licensed in Tennessee on 11/27 of 2012, and became the principal broker of Meridian National Realty, LLC, when it was first licensed in Tennessee on 2/13/2013. Meridian Property Management, LLC, currently has 2 affiliates and no brokers. The affiliated licensees of both firms live within 50 miles of the firm office location. According to the TREC records, Mr. King has no complaints filed against him and no formal disciplinary action has been taken against him. The California records likewise indicated that Mr. King has had no formal disciplinary action taken against him. Mr. Finn has worked for Meridian Pacific Properties since 2010 and is currently working as the business development and investment manager. Prior to joining Meridian Pacific Properties, Mr. Finn worked for Marcus and Millichap. Meridian National Realty LLC, according to their website, acquires, renovates, leases, manages, and sells A-class single-family investment properties and portfolios with a focus on the Memphis, Tennessee area. Meridian has established a business model which provides investors a premium turnkey real estate investment along with property management. Meridian is a market which includes private investors, asset managers, and REITs. The firm utilizes technology to teach, coach, mentor, and supervise agents throughout their offices. The principal broker of each licensed firm, is charged with the ongoing responsibility of teaching, mentoring, and supervising any affiliated licensees in their firm. Mr. King has stated that he is currently and will remain actively involved in the daily operations of the firm and will be actively involved in mentoring and training Mr. Finn. Mr. King does reside in Memphis at the present time.
All right, let's get started here. Who's Mr. King? All right, good. And Mr. Finn, you flew in from California to be here? That's true. All right, how'd that story go? Is it accurate or?
Yes, I'd like to make a few small modifications. Mr. Finn
You've got the floor, and you can do that, because I'm frankly confused about a couple of things. So anything you can help out with would be great.
Mr. Finn's actually an employee of Meridian Pacific Properties. Meridian Pacific Properties purchases assets, we renovate them, and then at certain times we will actually sell those assets to funds or people, individuals. So basically, we're selling our own properties. We aren't engaging in the public. We don't list through the MLS or anything of that nature. Mr. Finn does not get a commission for anything he does, or will not get a commission for anything he does if he's so licensed. What I felt important was I've been the primary broker and the primary seller, and I've worked with all the different funds that we've worked with, and I have recently moved and established more of my time or residency in Tennessee, and I spend most of my time in Tennessee. I fly back and forth to California every month for at least a week, sometimes longer, because my business is both in Memphis and in Tennessee. So I believe that, as a employee, Mr. Finn, moving forward, Mr. Finn could start selling properties for our company, assets that we want to dispose of, without licensing, as long as he's not commissioned in any way, which he will not be. Since I'm not in California as much as I currently used to be, I'd like to see if I could get Mr. Finn to do that. He's been our project coordinator, and he's basically helped us, coordinate all the closings and everything up until this point. I felt important that he get licensed, or at least go through the education process, because he will be a steward of our company and real estate in general, and I want to make sure that as he does deal with the public, he'll be able to communicate properly and follow all these appropriate rules and such. So I did require him to go take the testing, take all the coursework, and since he's done that, I'd like to see if he could be licensed.
Commissioners, any questions for Mr. Finn?
Yes. You live in California.
Yes, sir.
You're going to be managing the firm's assets in California?
So let's just get this clear. So you want him licensed in Tennessee so he can sell properties in California?
He will be selling our firm basically purchases properties in Memphis, and most of the funds that we deal with are located in California. So when we're selling to a fund or to a family office or something like that, they're primarily located in California. So I wanted to make sure that Michael knew all the rules and regulations and everything else from that.
So your investors are primarily situated in California, and your properties are primarily situated in Tennessee? Okay.
And they're managed by our in-house property management entity. So they'll be tenanted, and they'll have.
But you'll still live in California, and you'll function for the company in California. I'm not seeing the connection for the Tennessee license.
Gentlemen, if you will make an effort to speak into the microphone so we can pick this up as well.
Sorry. What I want to make sure of is that Michael understands all the rules and regulations in terms of just, working with the general public funds or whatever. I realize licensure is not required to sell company assets, but I also think being a good steward of our assets and ensuring that, he can do it and do it properly and make sure he's following all the rules was important. So to me, it was really a function of making sure he was well educated. Since he's gone through the education process, I wanted to appeal to the board. I will be managing him. Daily, we sit down and talk on a daily basis. Every Monday, we have a 3-hour meeting, be a go-to meeting, and I fly back there. Literally, I've done it for 5 years now. I've been back there for at least a week, in some cases 2 or 3 weeks, as I travel back and forth to both places.
I applaud you on wanting him to be educated here and knowing our laws. But I guess I'm just a little confused too, if he's still going to be in California, as to why he wouldn't even need a license here. I think what you've done in getting him educated is the best thing you could have done, but
I wanted to make sure that, one of the things that, was on record earlier is I've never had a complaint. I've transacted over 1,000, transactions. And, I have a very clean record, and I want to make sure I've come before everybody, kind of disclosed what we're doing, wanted to make sure that there weren't any issues or I haven't there's a million rules. I try to keep on top of all of them, but, it's this way. I'm standing in front of the board saying, this is what I plan to do with my employee. And if you felt that it was important that he, be held to a higher standard, I do as well. And if he can operate without licensure, I'm fine with that as well, and it's on record that he has gone through the training and all that kind of stuff. But if a license is granted, I'm here to tell you that I will be monitoring and working with him on a daily basis and make sure that everything's done right.
Commissioner Franks.
as a principal broker in the state of Tennessee, I have one of my very high-selling agents moved to Adams, Tennessee. My office is in Franklin, and it was beyond the 75 miles that we have a 50-mile rule, and we have given exceptions up to 75 miles. I had to let my very best agent go because of that. We have never had anyone come in and ask for an exception from that far away. I mean, it's a new record. And as a principal broker, I know there's no way he can be in California and you can be overseeing what he's doing. So I'd like to make a motion to deny this request.
All right, there's a motion on the floor offered by Commissioner Franks to deny the request. Is there a second to the motion?
Second.
All right, we have a second by Commissioner DeChara. Let's have discussion on the motion.
Well, I'm a bit conflicted because what Mr. King's trying to do is pretty honorable. But I don't see the necessity to have a license for Mr. Finn. But I really like what he's doing. He's bringing everything forward and saying, I want all my employees to abide by the rules.
I agree with that. But it's laid out in our rules and our laws what it takes to be an affiliate broker in the state, and it makes me nervous that how do we even follow this if it's going on in California? So I just think it's beyond the realm of possibility. I do applaud him for wanting to do the right thing, but and he's here obviously because he read the laws and knew what he had to do. But I just think that I don't know if it's necessary that he have a license here or not. I know if he's doing any of the things that classifies as an agent in the state of Tennessee, he needs a license. But I just think this is way beyond the scope of anything that we've had come before us, and it sets a precedence for somebody to come in and like my agent that moved to Adams said, well, you let somebody from California.
So it sets a huge precedence, which means we might as well do away with the rule in the law if we're going to let somebody from California have the exception.
Mr. Finn, can I ask you a question? If you'd like to speak first before I ask the question, go right ahead.
As I mentioned earlier, I mean, most typical real estate firms in Tennessee would have a cadre of agents that would sell to the general public in a local environment. We sell all of our properties in California. So the only time we actually sell is through a very controlled, scenario where I fly back, I talk to people that want to, I talk to people that want to purchase the properties, and basically I dispose of the properties in that manner. In the future, I would like to fly back and work with Mike to dispose of those properties, and someday Mike will work on selling those. So we're not in a situation where we really use the local market at all. Very rarely will we use the local market, and I've got a firm, Meridian National Realty, and I do have an agent that will list it on the, on the MLS and, do it in the traditional fashion. So from that perspective, almost all of the property sales that we do are out of state in a sense. So it is a little different than trying to and I guess my point was 100% of my energy is really going towards California and the sales over there, and we'll be managing one person versus, having, 20, 30 different agents and trying to, work with. I dare say that Mike gets more of my time than most agents in Tennessee get from their broker.
I'm sorry, Mr. King, so I want to ask this question to you. You mentioned I've got a couple questions. Meridian Pacific Properties, what is that?
It is basically a brand that houses a number of different companies underneath: Meridian Capital Group, Meridian Property Management, and Meridian National Realty. Meridian National Realty is our local firm that basically sells real estate in the traditional fashion. We do very few transactions that way. Meridian Property Management is obviously the property management firm, and Meridian Pacific Properties is the company that buys and holds these assets, for periods of time, and then sells them to funds or whatever. We'll aggregate homes and sell them to funds.
So if this went as planned, Michael Finn would be associated with Meridian National Realty?
We would actually have him associate with Meridian Property Management, only because Meridian National Realty has the MLS, and Meridian Property Management does not, since he won't be doing anything with the MLS, nor does he really need that specific tool. We'd affiliate him with that particular organization.
So Julie, so both these entities are LLCs. So can an employee sell property for an LLC? According to that Attorney General's recent.
Doesn't fall under our licensing exemption for an unlicensed person to work on behalf of an LLC. I think those are a little bit different circumstances in here, because his firm is also the firm itself is the LLC. Is that not the
Right,
licensed
but
firm?
if Michael is an employee of the firm,
Two licensed firms.
not a licensee but an employee.
Large company, Meridian Properties is a corporation, isn't that right?
Meridian
That's what I
Pacific
thought.
Properties is
It's
a corporation.
Correct.
It's got we hold all our assets under various LLCs that, in many cases are disregarded from a tax perspective and report up through Meridian Pacific Properties.
So if he doesn't get a license, he'll continue to be an employee of Meridian Pacific Properties?
Correct.
Okay. Which is incorporated. Austin?
I have a question, and this may be for Ms. Kropp or Ms. Maxwell or maybe one of the commissioners, if you could help me remember. But how is this application similar to or different from the ones that we heard from Whitetail Properties? If that's the name, do you remember what I'm talking about? Okay, that we heard several times.
Well, he's not actually going to be located here selling properties. It's actually reverse of what Whitetail is
Whitetail,
is listing and selling
right,
properties.
the big company, the corporate entity, was in Illinois, and they had a broker at first they wanted to just have him be a part of the Illinois company and licensed here, and the commission turned him down on that. And then they wanted to have a situation where the broker, the principal broker in the firm, were maybe 150, 200 miles from the individual, and the commission
It
turned
was
him
like
down.
a Cookville to Memphis
Right, and
situation.
then
Okay.
they ended up with a situation where the person was, I don't know, 100 and, like relatively close, I guess, to the individual. But they had a firm here, in Tennessee with the principal broker, and the individual was living in Tennessee. It was just further away than 50 miles. And so this situation is a little different in that Mr. Finn resides in California, and the firm is located here, and Mr. King is located here. At least I think his residence is here in Memphis. So it's a little different.
Is there a standard in the law, either in our rules or in the statute, as far as how we're supposed to make a decision if we're going to grant an exemption to the 50-mile? What does it say?
It says basically that no principal broker shall engage a licensee other than a property manager who lives more than 50 miles by a straight line calculation from the firm office, unless the principal broker demonstrates in writing to the Tennessee Real Estate Commission's satisfaction that the distance involved is not unreasonable and that adequate supervision can be provided.
Excuse me, Julie, what is that number?
That's Rule 1260-02-.01. It's entitled Supervision of Affiliate Brokers, and it's the second paragraph in that rule.
Included like in a copy of the letter that you all have, that one of the letters I wrote to Mr. King. You'll
So-
see just the quote of the rule if you need it for reference.
So although the location of the affiliate and the principal broker are sort of reversed from the initial Whitetail property situation, like Commissioner DeChara said, otherwise this sort of feels like the initial application that we denied for Whitetail properties, where you had the out-of-state at a pretty significant distance principal and the in-state affiliate.
That's right.
To me.
It was Indiana.
I do think they were
There
more,
were-
yeah.
They were, I think that in that instance, they dealt more with the general public than it sounds like these gentlemen are doing. I mean,
Right.
they're dealing with a select pool of investors as opposed to
Right.
going out on the MLS from how they've described it.
That's correct.
Yeah, so you do have that issue, which kind of cuts in the other direction, that the fact that they seem to have real limited contact with the general public may lessen some of those concerns about supervision, I guess.
But a license in Tennessee enables him to do anything that a licensed agent could do in this state. If granted to him, he would be able to do any of those things that we all do.
Sure. Commissioner.
Mr. King, tell me again what your proposal is for Mr. Finn of the various companies or LLCs that you own or you manage. Who would he be affiliated with?
Affiliated with Meridian Property Management.
Okay, thank you. So now 1260-2-01 says, no principal broker shall engage a licensee other than as a property manager.
That said, though, he wouldn't be doing property management.
Oh, you
That
just
was-
did that for the MLS?
Correct.
Yeah, that was
Okay.
primarily the reason for putting him
Okay.
under that
Okay.
particular entity.
All right.
If I may speak quickly, I think largely what we're looking for is approval of the type of transactions we're doing. If the board sees the license as not a necessity, I'm not looking to have the luxury of operating like an agent to do all of the flexible sales that you might do in a primary homeowner residential, but we want to make sure we're not violating any agreement doing the transactions that we're proposing. So that's why we filed for the license, to make sure we were covered.
So are the properties syndicated, or the investors in the syndication?
No. You know, they're just either one-off homes sold 5 at a time, 10 at a time, but they're basically
They
purchased.
can be accredited investors all the way up to institutional size investors that will come to us either through friends and family references or resources like that. And we're not farming for our own inventory. We're aggregating our own inventory through our property management and through our brokers that are in Tennessee.
Well, it sounds to me like you can do what you want to do as an employee. You're not going to come to Tennessee anyhow, apparently. Is that generally true?
I come usually quarterly to see the homes and meet with investors.
Okay, as an employee of Meridian Pacific Properties, Inc. Okay.
And so are you negotiating with those investors?
That works through Jeff.
I think there's some issues here at play that you all may not know all of these facts, and I'm not sure about giving them an opinion that what they're doing is A-OK based on a 15-minute verbal representation.
I don't think we're going to say
Okay.
we bless
That's what
the
they seem to be
model,
looking
but
for,
I think
though.
if Ms. Franks' motion passes, I don't think that, based on what you all have said today, it will prohibit your business model from continuing to work.
I think the question is whether to grant the 50-mile
Right.
exception. That's the only question that we're dealing with today. And I think we've got a motion on the floor, and I'm ready to vote if everybody else is.
It sounded like a call for the question to me. Is there an objection to the call? All right, I don't hear any objection. Let's vote on the motion. The motion is to deny the request to waive the 50-mile rule. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. And with that said, man, good luck. It's nothing personal, I promise you.
Sincerely appreciate the time here. You guys spend an enormous amount of your time, and I appreciate the dialogue and everything as well.
And I do appreciate the fact that you have gone to the efforts that you have to do it right and to get him educated on what our laws are. I truly do appreciate that.
And you're all welcome to come to any of our meetings, because you can learn some more stuff here.
Thank you so much.
Thanks,
Or you
guys.
can-
Good luck.
You can watch them on YouTube
Yeah.
from California.
In California?
Yeah.
All right, Executive Director's report.
Yes. The first thing I want to talk about are the seminars. I mentioned them at the the Tennessee Association of Realtors question and answer session last Tuesday. We are going to be offering some seminars. There'll be 1 hour that we're going to dedicate of the seminars to principal brokers. And in that 1 hour, we're going to have our auditor, Ahmad Lewis, go over the items that are needed for the audit if you get an audit letter, explain a little bit about reconciliation, sort of what the expectation is, so that hopefully the principal brokers will not be, taken aback by what the audit requests and understand fully what the audit letter does request, and then give them some, hopefully give them some additional tips on how actually to reconcile your books and make sure that, this information is easily, given to us when we ask for it. So we're hoping that, and we're going to then talk a little bit about supervision as well, if we fit all that in 50 minutes, which we hope to do. We do hope that we get a lot of principal brokers who want to participate. Typically, they do not come to the seminars, and so we just hope by doing this for an hour at the beginning of the seminar that they'll come and they'll listen and ask questions. And right now, for until the 1st of July, we're just doing the seminars in sort of this immediate 50-mile radius area around in and around Nashville. We also, after the 1 hour seminar for the principal brokers, we're going to have the typical 2-hour seminar that we always have for all licensees. When we talk about the complaints and issues of the day, and we talk about E&O. So if a principal broker wanted to stay for the whole 3 hours, from 9 to 12, they could get 3 hours of education. If the commission approves that today on the education report. And if they only want to stay for the first hour, then right now we can't give them credit. But if the governor signs the new statute, then they would be able to get that 1 hour credit after July the 1st of 2015. It wouldn't be applying to anything that happened prior to that time. And then the 2 hours, or the typical 2-hour seminar, and you would get credit for the 2 hours if you came to that. Actually, the principal broker hour, we can't keep people from coming, but it is going to be geared towards principal brokers. And any suggestions that the commissioners might have about things that we could add to that. As I said, we've got it right now for that 50 minutes. So I know Ahmad explaining things could take a period of time. There would probably be questions from individuals, but we do want to talk a little bit about supervision, since that is such a big issue, and the licensees the principal brokers who get the complaints for failure to supervise, and explain that a little bit so that they can, understand a little bit better about what that complaint entails. We hope that, as I say, I hope we get a big turnout. We have the dates where we'll be. We're going to do 2 actually here in our building in Nashville. And so we hope that, maybe if you can't come to one of the other ones, that you'll be able to come. They start the 21st of April. We'll be at the Greater Nashville Association. And then on the 22nd of April, we'll be in-house. We'll be here at Davy Crockett. The 23rd of April, we'll be at the Middle Tennessee Association of Realtors. The 24th of April, we'll be at Sumner Association. And 27th of April, we'll be in-house. The 28th of April will be at Williamson County. The 29th of April will be at Eastern Middle Tennessee Association. And in June, on June the 23rd, we'll be at Clarksville. Now, all of those will be, the principal broker will be from 9 to 10, and the 2 hours will be from 10 to 12. And then, as I say, after July the 1st, we'll be fanning out to other parts of the state. And then, as I say, if that bill is signed by the governor, it may have already been signed, I don't know, then we'll be able to give 1 hour credit, which I don't know if that'll make it more attractive to the principal brokers or not, since a lot of them are grandfathered. But as I say, any suggestions that the commissioners have of things that would be of interest, particularly as it relates to the principal brokers, we'd love to hear it so that we could add those and make it, we hope it's going to be worthwhile, and we hope we'll have a lot of attendees.
How many are you going to have in other areas?
Once July the 1st comes, we'll have, we'll fan out like we always do. And we may not always, we're going to have to sort of see how this model works as far as reaching the principal brokers. I don't know if this is the best way to reach them. We've done one of these once before, but it was at the request of the association. So we had good attendance by the principal brokers, but that was something that the association requested us to come do, and so there was obviously an interest there that they had. I don't know what the interest level is. We're hoping that it's good, but we'll go, to Knoxville and Easton. We'll do what we've done in the past, which is cover all of the areas of the state as best we can do that. And as I say, I hope that we have a good attendance by the principal. I mean, I hope we have a good attendance, period, but particularly by the principal brokers who we would like to reach.
Who will be leading that class for the principal brokers?
Well, Ahmad will be discussing the audit letter and the reconciliation, and then I'll do the supervision part of it.
Now, I have a suggestion.
Okay.
It looks like a lot of time and effort is going to be going into this, and then there's travel time and things like that too. One of the things that our MLS RealTrax does is they do webinars so that you can access them, away from traveling. And I understand, for instance, Diane Hills from Kingsport, it'd be a long drive to come for that class. If there's some way that some of these things could be videoed and then put online, I think at least that would help people in the further areas. That would just be a suggestion, another way to reach them.
And in the past, we haven't had the capability to do that, but I think now we might have the capability to do that. I think that there's a person, I think Megan would probably be able to do that. I think we've got some people on board now in the Public Information Office that could probably help us do that so that it would be available. We wouldn't be able to have all those stopgap measures in that, but at least record it so people could watch it and see, just like you would a consumer tip on the website. I think that's a great idea.
And I think a lot of people look at TREC as this, it's out there somewhere. It's
right.
It's kind of like believing in God, but you haven't seen him yet.
Right.
I think it would be very helpful to get the information out. I applaud you for doing this too, and as the things are changing, everybody has questions about it. So
Right.
it'd be a great way to disseminate all
Right.
this information.
And as I say, I just hope we get a good turnout.
And I think particularly the 1 hour for the brokers on that audit, because if somebody then gets an audit and don't know how to do it, you can say, well, you can go to the website
Right.
and there's an instructional video there that possibly would help you with that.
Right, I think that's a great idea. That way we could put it on there for a point of reference. And I think that would be good, because not everyone we know will be able to come to the seminars.
Mr. Chairman, members of the commission, I have been in, along the same lines that Director Maxwell is discussing. I've had nothing but positive remarks from the locals that want to come and that they're going to put the information out to their individuals. So I'm looking forward to a pretty good turnout on each one of these, and it's been a very positive communication with me, and they're looking forward to it. So, but the idea of the webinar certainly is something I'll look into, and we'll see what we can do with our new marketing director here, and that may be just knock a home run there. That does sound really like a good idea.
And if not a webinar, just a video.
Right, yeah. And I think that probably would be what we'd have to do,
Yeah.
is like just video. But we are trying to start a series of public announcements that would be videoed and go on our respective websites. And the Public Information Office is working with us on those. And they've got the equipment, from what I understand, so that now, as I say, is a much more feasible alternative than it was previously. And I think that would be great. But as I say, any suggestions that the commission has, or questions that you get regularly from individuals, please let us know so we can incorporate that either into the 2-hour seminar or into the principal broker seminar, which is, I say, we can't keep people from coming. So if affiliates or brokers want to come to that and stay the whole 3 hours, they can do that as well. But we do hope that it'll, offer a lot of learning to individuals.
For the audience's benefit, the gentleman up here who just spoke is Ross White. He's the Director of Education for the Tennessee Real Estate Commission. So if you have any questions during the break about education, he's a good guy to ask. So I have a question for you. On a 1-hour continuing education credit, is that 60 minutes or is that 50 minutes?
50.
Why is it 50? Is it statute that says it's 50?
Our rule says that it's basically an hour shall be deemed to be 50 minutes. That's what.
Have a rule that says it, that's the right answer. I'll take it.
So you can't take a 15-minute break and then get out of class 5 minutes early.
Right, so
Or-
it's the 50 minutes, and then we can't give credit for that now, but if the governor signs or has signed, and as I say, all I know is what, has it been signed?
It's been sent for signature, but the last I checked, it had not been signed
Right.
yet.
So if he signs it, then we would be able to give credit for that 1 hour. But it does say that, doesn't it? Yeah.
Okay, just curious. All right, E&O update.
Yes. As you know, we suspended 2,822 licensees on 1/13 of 2015. As of 4/30 of 2015, we had 575 individuals who remain in suspension from that 1/13 of 2005. These individuals remain in suspension for failure to provide proof of E&O and actually to get E&O. We have 33 additional licensees that we've suspended, over the time. It's an ongoing process. We check it every couple of weeks and add, Betsy then adds additional people and we send letters to them. So it's an ongoing suspension process. But the 575 is the amount remaining from our original number that we had put in suspension. And as I mentioned before, 350 of those that we originally placed in suspension were in a broker release status. A fair number of those probably will not act on this, and they will just allow their license to then be revoked because they're in suspension, and after 12 months, the statute provides for revocation. And so a number of those people will probably end up in a revoked status. the breakdown of that 575, we have 311 affiliate brokers who are still suspended, 44 brokers, 83 principal brokers, 137 timeshare individuals, and that's what makes up our total of 575, and that represents about 2% of our licensees that are insured, which is, we have 24,788 licensees who are insured, and the suspended people represent about a 2% of that, which is way better than, substantially better than we had been, at least in 13. 11, we had fewer people that were not
Ms.
insured.
Maxwell?
Yes,
Those PBs, those 83 PBs,
right.
are the 83 PBs with active firms?
As we come across those firms, we're putting them in problem status. Some of them have expired firms. Some of the principal brokers are like expiring. It's kind of the same situation we had last time, where we had those principal brokers in that remain. If you remember, they just we had like 19 or 20 that just stayed in suspended status, and they ultimately were revoked. And then so it was a harder core group of people that were not going to get proof of E&O. But as we come across these, their firm, if it's active, is being put in problem status.
And so how are those agents made aware of that, or just the principal broker?
Just the principal broker.
So how would an agent know that their license is hanging at a firm that has a suspended principal broker and is in problem status?
Well, yeah, unless I went to the website, we don't send a letter to all the affiliated licensees. I guess we could just notify them when we put the firm in problem status.
Because how else would they know? Because the principal broker
Is not going to tell them.
No.
Right. They're not going to, I wouldn't think they're going to tell them.
They need the opportunity to move to another company, I would at least think.
Well, we could notify, I don't know how many of these principal brokers, at the time, I don't know how many actually have affiliated licensees, but we can notify those affiliated licensees and let them know that their principal broker, I can send them a copy. When I put a firm in problem status or a person in problem status, the suspension aside, but when they're put in problem status, I have a letter that basically tells them that they're in problem status. And so we could copy the licensees on that letter. And
Because probably a lot of these are one-man offices, right?
that's what the case was last time, is
Yeah.
that almost all of them were, I don't even know if any of them had any affiliates last time. Of this 83, probably some number do have some affiliates, but I would say probably by and large they're single offices. But we can do that and send letters to the affiliated licensees.
Well, I just have a problem with an agent out there thinking they're legal and doing business like they're supposed to be, and they've got a broker that's not legal.
Right.
They're going to get in trouble and not even know it, or potentially.
Well, right. They have somebody who's operating really without a license when they shouldn't be operating if they're in suspended status. And that does make it difficult. I understand back in the day it used to just release everyone from the firm if your principal broker license expired, or if the firm expired, or if you had some other event happen. And that must have at some point proved to be not a very workable solution, because then it's technically a fee to get, to transfer back to a firm. And so that must, I don't know all the reasoning behind it, but I think that was part of it. And you just had these people released, and if their broker came back in a week or 2 weeks, you had to put them all back. I guess it just became cumbersome to do that. But that's the way the system used to operate before I got here. But we can send letters if that
We
would.
need a motion in that regard?
No, I know.
All right.
You can make a motion if you want, but.
No, I'm ready to
it's-
move on.
Okay,
Okay, and a somewhat related topic.
okay.
How about brokers that have been suspended because they failed to pay their professional privilege tax, student loans, or child support?
So brokers that have not paid, they're sort of separate items. Brokers that have not paid the professional privilege tax, there is a hold on their renewal. So they're not in a suspended status, they're not in a problem status, as it were, they're just in a status where they cannot renew. So until their renewal comes up, they're not going to be affected, as it were, by that hold that's on their renewal. The professional privilege tax revenue is actually getting these individuals for any past privilege taxes that they owe. So some people think that they only owe the amount you see currently, which I think is now $580 some odd dollars, I think. But in actuality, if you didn't pay in 11 or 10, you're going to have to pay that whole amount. So it's not as simple as just, if you haven't paid, it's not as simple as just paying this year's amount that's due. But that won't affect you, as I say, until you go to renew your license, and that's a principal broker. But that, I assume, if you didn't pay last year and you're still in the renewal period, it'll be put on there again for this year. So it's just going to build more and more. So it behooves individuals to go ahead and pay that and clear it off, even though it's not renewal time for them, because the fees are still, and interest or penalties they're just accumulating. It's revenue, so it's accumulating. DHS, the child support, and the student loans, those instances, we receive orders or notices from the Department of Human Services and the Tennessee Student Assistance Corporation that tell us to place the individual's license in a suspended status. So when we receive that information, we receive the TSAC information every Thursday or Friday to put someone in a suspended status. DHS we receive quarterly. We have to then put those licenses in a suspended status, and we cannot take them out of that suspended status until we receive a notice from each of those agencies that says, this person is in substantial compliance with, child support or their student loans. You can now, remove that restriction on their license. So we can't do anything, even if a person has paid. We have people that say, well, I paid TSAC and I got it all worked out. But until we receive that official notice from them, we can't do anything to their license. It has to come from that particular agency. And as we had discussed last year maybe, or maybe the year before, the statutes of each of those the federal statutes and the state provide that we have to do the suspension without a hearing, without anything further. It's just like our E&O. The statute says we shall suspend, and we get suspended. And they suspend every license that you have, DHS and TSAC do.
Is that a significant number?
It's real, it kind of varies. There's some people that have been on there for a long, long time, but normally we get probably on every list on Fridays, we maybe have 2-3 people that are on it who haven't paid their student loans. And quarterly, when we get the DHS list for child support, we've had as many as 30 people on there, and then we've had as few as 5. So it because that's quarterly, it's a little bit different. And a lot of the people are repeats, and some of the people are already in suspension for E&O, or some people are in suspension for all 3 and have a privilege tax hold. So they sort of have a challenge to get back licensed, I think.
Thank you.
Uh-huh.
How about the complaint report?
The complaint report, get through all my E&O here. Complaint report is not on your iPads, but the penalty monies collected this month for complaints is $44,060. 17,000 of that came from consent orders, 24,060 from reinstatement fees, and 3,000 from the E&O civil penalties, which kicked in the 31st day after suspension. So we've had some of those individuals already pay, and they have to pay $200 right now if they are able to backdate and show continuous coverage, and it's $400 if they are not able to get their carrier to backdate to show continuous coverage. The total penalty monies we've collected this fiscal year, $366,230. And there's a breakdown of the monies collected and the individuals who paid those monies that you all do have on your iPads that shows that money collected. Right now, we have 174 open complaints. We have formal charges authorized on 21. We've closed a total of 316 complaints thus far this fiscal year, which is drawing to a close pretty quickly. And then I believe you have the DAR report on your iPads as well. So that's the complaint report. We are, we hope, going to hire a new complaint coordinator. Amy, who was handling our complaints and doing a great job, took a job in manufactured housing up on the 8th floor, and so she departed a couple of weeks ago. And we had already had in the works, we were going to try to hire that position. So hopefully we've interviewed people and we sent the information up on the person we would like to hire. So we hope that person starts soon, like last week. But we haven't gotten the final vetting from upstairs, but it's a person who we feel like will be a big asset and be able to jump right in.
Is it someone already in the office?
No, it is not. It's but it is somebody who it's somebody who's worked with the state before. And anyway, we feel like the person will be a great asset and they have a lot of computer skills, so we think that'll work out well.
All right, let's take a 10-minute break.
Okay.
10 minutes, hurry back. Members of the audience, just a point of information, this commission is subject to the Sunshine Law, Tennessee's Sunshine Law, so basically we cannot have discussions about items on our agenda outside of this public forum. So sometimes you may hear discussion between members of this commission. You go, sure, that's the dumbest thing, or why are they talking about that? We're talking about it because it's the first time we've been legally able to talk about it. And so if you find Commissioner Bloom and myself back here talking about an upcoming vote, then you ought to turn us in, and I don't know if they can arrest us, but we're violating the Sunshine Law and we can't do it. With that said, we're back in session, and Ms. Maxwell, our Executive Director, is about to talk about some statistics.
This is the statistics, the number of licensees and the changes through the years that we've had. Currently, as of 3/27 of 2015, we had 24,759 active licensees, 1,197 inactive licensees. We had 7,148 retired licensees, 338 in broker release. The suspended number, which does include all of the suspensions for DHS, TSAC, and E&O, and the ones that the commission have also imposed, 682. So our total number of active individual licensees is 34,169, and that's affiliate brokers, and timeshare salespersons. We have 3,993 firms, and our firm number has dropped. It continues to drop just a bit every month. This time last year, we had 4,091 firms. So the firm number is going down. I think that firms are just growing a bit larger than they were in previous times. The number of exams that were taken, this is like the third or fourth page. I don't have numbers on my pages. It's like the third or fourth page on your iPads. The number of exams that were taken in March of 2015 is 546, which is an increase over February, which was 410, and January of 15, which was 353. So there has been a significant increase in the number of exams that have been given. And whether or not those all become licensees, we don't ever know. Individuals have 6 months from the date they pass their exam to turn in an application. Under the statute, that's the time frame that they've got. So some people will turn those in and never complete them, and some people will turn them in and they'll be complete, and then some people just won't ever turn them in. They'll have to retest and reapply if they want to get a license. We approved 386 applications this month, which was an increase as well. You can see in January, we approved 222, and in February, we approved 330. So in March, we had an increase at 386. This is only applications that were approved. It doesn't include like all the Trek 1s. We probably process over 1,000 Trek 1s a month for since the Trek 1 does 11 things, it sort of encompasses anything anyone might want to do. So these numbers don't encompass the Trek 1s. Hopefully when we get our new computer system, we'll be able to easily track the Trek 1 forms that come in. The types of the exams the exams taken by license type, we had 8 acquisition agent licensees take exams, 469 affiliate broker exams, 33 broker, 36 timeshare salesperson, which completes the total. This is the time of year that the timeshares really start to beef up their sales force. So we usually see a fairly significant increase in timeshare applications during this time of the year as the spring and the summer come to the mountains for people who go to the mountains to visit, which is where the timeshares are primarily located. Are there any questions about any of the statistics? I mean, I can go through some more, but are there any questions? If not, we can move on to fingerprints, which is just that's not on the iPads. Or yeah, it is on the iPads. I take it back. It is on the iPads. The number of applicants that have been fingerprinted is through 3/31 of 2015 is 1,036. The number of reports with indications, which means that your fingerprints have come back with something showing some sort of interaction that you had with the police or other authorities. So that's about 20% of our applicants have had reports with indication. We've had 796 with no indication, 20 with no read on their prints, and those individuals with no read on their prints we send them a letter and they can go back within 60 days and have their prints taken again for free, and if they do it within that 60 days. This month we had 14 individuals that appear to have missed their fingerprint appointments, which is, I don't know, odd, because normally you see 1 or 2 A's for absent, but this month we had more. I don't know, maybe the weather, yeah. That might have been the case. But the fingerprints are going a lot smoother. I mean, a lot of people are they're getting them before they test or as they test, and they're sending in the court dispositions if they think there's something on their report. A lot of times the reports come back with things on that people didn't realize were on there. But anyway, that it is going a little smoother as far as getting those and getting them done quicker. I'm now reviewing them all before they're given out to the techs to see whether, the ones that have indications, to see whether they need additional information so we can try to move that along a little faster, the printings.
Ms. Maxwell?
Yes.
I read in our local newspaper where there was a gentleman arrested for trying to use his fingerprint for someone who was trying to get licensed for selling real estate. Do you know anything about that?
I don't know very much about it. I read just a short article about it. When we first started doing the prints, probably in February of 2014, I received information, very, very just a small amount of information from the TBI that said an individual had come and tried to have someone else give their prints. I don't think it was the individual. I don't think the person we had the application on was the person whose name was in that story.
It was a person that they arrested.
Right.
But I'm interested in the name of the person who they were trying to use their fingerprint for.
Oh, I have that name upstairs. The person was not licensed. I mean, they never received a license. The TBI, I guess the person tried, as I recall, 3 times, and the TBI all they did was really send us information that if the person were to come into our office with a paper card of fingerprints, that we were not to take it.
So
and
you
that
have
was,
them flagged some way?
We had them flagged, yes,
Okay,
and
that's all
everyone in our office knew. The people in our office We didn't know, we knew nothing more about that. We didn't know why
Yeah.
we had no background information and they didn't give us any. But we told everyone in the office that if they were in there and the person came in with paper prints, not to accept those paper prints. And that was all we ever knew about it, and the person was never licensed. And I don't know whether they had prior knowledge of that person or not. I mean, I really don't know. But that's, it was sort of interesting that happened. The next item is the last item on my report is the budget. And that I sent that's of February 28th, 2015, which I sent to the commissioners. Are there any questions about the budget? If not, that's the end of my report.
Thank you, Ms. Maxwell. Appreciate it. All right, Ben Wilson, Tony Gaines, you guys here? Ben Wilson? All right, it's a little early for when they were supposed to be here, so we'll stand by. I do know Wallace McClure is here. If it's all right with commission, we'll go ahead and take his item on the agenda a little bit out of order, unless there's an objection. All right, Mr. McClure, will you come up, take a seat in front of a microphone? Maxwell, are you going to give an opening?
I will. I'll just sort of read just a little bit, and then Mr. McClure can continue on with his information. Wallace McClure, number 1455, is the principal broker of McClure Realty Company, number 247029, located in Knoxville, Tennessee. Mr. McClure's broker license expired on 6/22 of 2013 for failure to pay the $80 renewal fee. Mr. McClure is requesting that the commission grant him an exemption from the reinstatement policy 2013 CPS 002, reinstatement of an expired license, and waive the requirement in the reinstatement policy, which requires licensees expired over 12 months to retest and reapply and meet all current licensure and educational requirements. Mr. McClure requests that the commission allow him to reinstate his license without retesting and reapplying, without meeting the current licensure requirements, but instead to pay the renewal amount and have his broker license number 1455 reinstated. Mr. McClure was first issued an affiliate broker license on 3/10 of 1954. Mr. McClure was first issued a broker license on 6/14 of 1955. Mr. McClure has been continuously licensed as a broker since that time and has been the principal broker of McClure Realty Company since 3/1 of 1999. There are no other licensees affiliated with McClure Realty Company. Mr. McClure stated that his firm employed an elderly computer operator administrator who was responsible for a number of items, one of which was the payment of license renewals. The computer operator administrator had been with the firm for quite a while, but Mr. McClure stated that her health had significantly declined, and Mr. McClure did not personally see the renewals which were sent to his office, but it assumed as in past years, the computer operator administrator paid the firm renewal and the broker license renewal online by credit card. The firm license was renewed on 4/2 of 2013 and has a current expiration date of 6/10 of 2015, but Mr. McClure's broker license was not renewed at that time. While Mr. McClure assumes that the renewal notices were received at his office address, which is 114 Durwood Road, Knoxville, Tennessee, 37922, he does not believe that license renewals were received at his home mailing address. The track records indicate that on 3/25 of 2013, a renewal notice was sent to Mr. McClure at his home address of record as of 3/25/2013 and to his firm address of record. Mr. McClure's home mailing address of record with TREC is 114 Durwood Road, Knoxville, which is the same address as his firm. This home mailing address has been the mailing address on record with TREC since 2004. From 6/10/1994 until 2/10 of 2004, Mr. McClure's home mailing address of record was 7116 Crest Hill Drive, Knoxville. No mailings to any of these places were returned, and as we've mentioned before, state mail is not forwarded, so mail which cannot be delivered is returned to TREC, and we note that in the file and try to resend it if there's a forwarding address. TREC is not by statute or rule required to send out renewal notices, but the reminder renewal notices are sent out as a courtesy to both the home address of record and the firm address of record approximately 3 months prior to the licensee's expiration date. The Tennessee Real Estate Commission adopted Commission Policy Statement 2013 CPS 002, which does provide for the reinstatement of an expired license. The reinstatement policy only provides for reinstatement of a license during the first 12 months following expiration of the license. After the 12-month period, the reinstatement policy requires that the license expired more than 1 year reapply for licensure, meet current education requirements, and pass all required exams. And Mr. McClure, as I say, is requesting an exception from this particular rule. And you all saw a letter that he had written as well.
Mr. McClure, would you like to address the commission?
Thank you for allowing me to appear before you. You've done a very masterful job of explaining most of the things that I had on my sheet here, so I'll try to go between the two. As you mentioned, we had 2 real estate licenses, and one was renewed and one wasn't. And we also had an office staff of 2, one the secretary that did the computer and the mail and the administration, and I do the telephone and the work with the builders and the other realtors and the contractors and subcontractors. And she gave a report on the office staff. She'd been with me over 30 years. She'd had a stroke, and she's no longer with us, and certainly in declining health. And she's the one that received all of the mail. What kind of work do we do? We build homes and subdivisions, and of which we own them. And then we have one subdivision for Clayton Bank and Trust, where we operate that as our position as director. So we convey all of the homes in each. One as Wallace McClure Jr., trustee, and the other is Wallace McClure Jr., director. I value my real estate license. I value my MOP listing service, and also been active in the Knoxville Association of Realtors, the Governmental Affairs Committee. For 10 years I was chairman. I was also Realtor of the Year about 10 years ago also, and been in real estate all my life, and graduated in real estate at the University of Tennessee, after which I went in the Army. I'll be pleased to answer any questions that you would like of me.
So, to the commission, I want you to know, I know Wallace, and I can give you some background, but what I'm most impressed with, and then I'll turn it over to you, is you got a birthday coming up in June. Is that right? When's your next birthday?
Next birthday, July 9, this year, 2015.
And how old will you be?
85 then?
Yes, thank you.
Yes.
Okay, just checking in. Okay,
Right,
Mr. Blue.
right. Who wins that battle?
Mr. McClure, you're here today, and is it correct that your request is that the commission allow you to reinstate your license without retesting and reapplying and without meeting all current licensure requirements, but instead to pay the renewal amount and have your broker license reinstated? Is that correct?
That's correct. I place myself at the mercy of the commission.
I'd like to so move that.
Second.
Motion by Commissioner Bloom, seconded by Commissioner Franks, that your request be granted, Mr. McClure. Now is there discussion on the motion?
Well, I have a question for him.
Please.
Why do you want your license back? Everything you do is personal. Is it?
Well, one, I guess I've always had it, and two, it relates to the Board of Realtors. It goes through the MLS and all my designations, CCIM, CRB, all. My house of cards has absolutely collapsed. I called the realtors to ask them on this matter what to do, and immediately, click, I'm no more. You'd be shocked at how fast one can be a nothing. Out here, McClure, who's he? Right, it was shocking.
Well, Mr. McClure, you are a special somebody. Don't let anybody tell you that.
Well, thank you.
Okay, so, Mr. Bloom, back to your motion. I think we ought to identify what that reinstatement fee is, as far as dollars. Do you,
What was your motion that he pay the reinstatement penalty
My
fee, or was
motion
it
is
just
what
that
he requested in his letter.
Pay the fee.
since we don't have a fee past 12 months typically, I think we ought to insert a dollar amount in there so it's not, there's no question about how much.
Said pay the renewal amount.
Just the $80, is that your motion?
That's fine with me.
Mr. McClure, I know that my dad, you remind me so much of him in that he still gets up every day just like he's going to work, even though he hadn't worked in years. So I understand that keeps you young.
It does, it does. I got up this morning in Knoxville and drove over here.
So, Commission, as I understand the motion, if it passes and Mr. McClure pays $80 to get him current, but then you've got another license renewal coming up this year as well, right? I mean, let's say you...
For the firm?
Well, no, he was delinquent in
his personal.
2013.
Right.
So we're going to get you caught up if this motion passes, but it's likely the same thing could happen if you don't renew your license again in June or
Right.
July, whenever it comes up.
June, like, so on 6/22 of 13, if the motion passes, so that was when your license expired, and when it's reinstated, it's back to that date as if it didn't expire. So then on 6/22 of 15, you'll owe your individual license renewal,
Ready to-
and then your firm comes up as well, so you'll have both of
Just go
those.
ahead and pay them all if I were
Right,
you.
right.
I'll pay what you tell me to pay.
Okay, is there other discussion?
Call for the question.
Okay, the motion, the question has been called. The motion is to allow Mr. McClure to be reinstated in good standing with the Tennessee Real Estate Commission by paying a fee of $80, which will get him current. Doesn't pay in advance. All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Thank you, Wallace. Good.
Oh, thank you very much.
Hey, Wallace, how many houses? Hey, Wallace. Wallace. How many houses do you have under construction right now?
Right now, about 10 or 11 or 12 somewhere.
Better get back there and take care of them.
Good luck to
Okay,
you.
guy. Hey, Wallace, one more question. Did you bring a checkbook?
I've got a credit card.
You want to take it?
We can't take credit cards.
Oh, we cannot?
You want me to write a check for you and you pay me back?
Right. I'll get a quick check to you. Right.
All right, thank you, Wallace. Appreciate you coming down. All right, Mr. Gaines, Benjamin
here.
Wilson. Okay, is Benjamin Wilson here?
He's stuck in traffic. He'll be here.
Okay, we'll come back to you when he gets here. Just let us know. We've got some time, so why don't we go to the education report?
Education report?
Mr.
right,
Mr.
Mr.
White?
Chairman.
Let me find it on my iPad here.
There, if you go to just the list, you'll be able to see it, not the pictures.
Yeah, we're all on the list.
Are you on the list? Okay.
John just has issues.
It's on
As
the third
usual.
row if you've got the books.
Mr. Chairman, members of the commission, when you're ready, I'm ready.
You've got the floor.
All right, thank you. The April education report, I've got and have reviewed all the matters A1 through A35. There are two matters at the end for discussion. I think we could, the commission can take those up one at a time if you will. And I have an add-on based upon the discussion that we had this morning about the 2 hours for the affiliates versus the 3 hours that would include the principals and the affiliates. So I'm going to pass these out to you.
Let me ask you this,
Well-
Mr. White, are you recommending that A1 through A35 be approved?
Yes, Mr. Chairman.
So moved.
Is there a second?
Second.
All right, we have a motion by Commissioner DeChara, seconded by Commissioner Franks, that courses identified as A1 through A35 be approved. Now, the motion is not to the instructors at this point,
No.
just the course.
Just the course.
Okay, is there discussion on the motion? Let's vote. Those in favor say aye.
Aye.
Those opposed, no. That motion passes unanimously.
Mr. Chairman, my vote is yes, but I am going to abstain with respect to course number A10.
Is that because you're involved in it in some way or another?
Yes.
Are you the Esquire listed there?
He is Esquire.
Wow. All right, so that motion passes unanimously on all courses except A10, and Mr. McMullen recuses himself for cause on that one. All right, Mr. White.
Continuing on, Mr. Chairman, I have passed out to you an add-on that reflects our seminar that will give the 3-hour versus the 2-hour that's on the agenda. But this is an add-on, and I wanted to present that to you and perhaps for a vote separately.
Motion to approve. Second.
Okay, you've heard the motion. I have a question for you. So if somebody just comes and wants to take the principal broker session, have we approved that course?
This will be part of this approval today.
So this looks like a 3-hour course approval to me. As long
What it
as,
says.
Until the statute change that was proposed, and at least as I heard last week at the Q&A, right, that it had gone to the governor's signature. It has an effective date of 7/1 of 2015. So until that time, the commission no one can offer a course for credit that's less than an hour. So that's why we'll come, in June, if that gets signed, and ask for approval for 1 hour of that. And then then we would have a 1 hour, a 3-hour, or 2-hour. And so, but we're going to wait until that time to make sure that it's something we can do.
So all the seminars that take place prior to that, then, you're not going to give them the 1 hour credit on the audit then?
No, we cannot do, we can't. And so they can stay the whole time and get 3 hours, but they can't just get the hour. They're just going to have to come because they want to come and learn.
Thus, that's the reason for the add-on.
Okay, so the instructor is so would Ahmad not be one of the instructors?
He would be he's one of the instructors of the 1 hour part of the course, right?
But
So he
on
would be,
this add-on.
On the add-on,
Right.
regretfully, yes, he should be added on to that. Ahmad Lewis.
Which we'll have to approve him separately as an instructor since he hadn't been an approved instructor before.
I think that the commission will take that up under the instructor approval.
okay, the motion on the floor is to approve a 3-hour course sponsored by Trek and presented by Trek. Is there discussion? Let's vote. Those in favor say aye.
Aye.
Those opposed, no. That motion passes unanimously.
Thank you, Mr. Chairman, members of the commission. We have 2 matters to discuss. One involves D&D School. It's at the end of the agenda there under the discussion. D&D School of Real Estate contacted Mr. Richard Clemmer. He has indicated that he, in a past meeting, I believe that was the March meeting, he was approved for a Trek Corps 2015-2016 through Hondros. That's the provider there. That's the Arello-approved provider for his distance courses. There is a second course he wishes to pursue under Dearborn Kaplan that would be the same, essentially, course, Trek Corps 2015-2016. The issue is he's already approved for the one course through Hondros. I wanted to bring it to the commission, and I think Director Maxwell had some concerns as well for you all's discussion and consideration of that.
Are they approved by Arello? Dearborn Kaplan?
Yes, the courses are.
What is your concern, Ms. Maxwell?
I mean, we don't, typically we don't have someone that has numerous providers for the same course. It's really, he wants to bundle them up differently and offer different bundles with different providers. So, we weren't sure whether that was something the commission wanted instructors to do.
He's wanting to do his own thing.
Correct. Well, he wants to do one thing with Hondros and another thing with Kaplan, and bundle them differently, depending on, I guess, the price that I pay to the provider.
And why does he want to do that?
Well, that was our question. I mean, that really was sort of our question that we couldn't get a real answer on, but we thought we should bring it to the commission. So, because we couldn't get a real straight answer on that, but didn't want to be pursuing something if the commission was, thought that it was fine. We didn't want to be pursuing, asking these questions if the commission, didn't see a problem with it.
So has he provided a syllabus that we have seen that covers everything by combining the two?
He's not-
We've
There'll be
approved
two
it,
separate.
right?
There'll be two separate ones. So one has been
Be
approved.
totally separate. He's
in
not
March.
combining
Right.
two.
Right,
Okay.
it'd be, so they're separate bundles, so you'll have one bundle
Okay.
that might go through Hondros, or would go through Hondros, and one bundle that would go through Dearborn Kaplan, so they'd be different, they'd bundle the
Okay.
courses, and you can get,
It's going to be the same course, just different providers.
well, basically the same course. I mean, they each write a course, and they're ever so slightly different, I guess, but the same, covers the same basic material, right? And as I say, we didn't want to continue to ask questions that, if the commission thought it was fine, that's fine as well.
So each one of those would be it would be totally, if I took that core class, it would either be totally Dearborn Kaplan or it would be totally the Hondros, right?
I think that's what he plans
That's
to
our
do, bundle them.
understanding.
Okay.
Yeah, that's what we do understand, that he plans to do the bundles. And,
Okay.
One other thing for consideration, Mr. Chairman, members of the commission, that in an email to me, Mr. Clemmer stated that my marketing plan for this year is designed around this.
Could we maybe table this until our education director and our executive director are comfortable? Because I'm not comfortable if you're not.
I second that.
I think that we kind of wanted some direction from the commission, whether they're comfortable with an arrangement like that or not, because we don't, as I said, we asked a number of questions from Mr.
Have we
Clemmer.
seen the syllabus for both
Yes.
courses?
Yes.
Yes.
And you're happy with that?
Yes, it's not a matter of the syllabus. The courses both stand on their own, and they're, good, solid courses. It's really a matter of his bundling these two different providers with two totally separate core courses. You wouldn't get credit but for one. You couldn't take both bundles. But it's just that he's bundling them under two providers, the exact same course.
I don't know that I have a problem with that.
I'm just wondering what y'all's concern is, though.
It just is.
I think she's just saying it's not typical, and that's why she wanted to bring it to your attention. Make sure you all didn't see anything
Untoward.
untoward. It's just not typical. Is that correct? Right.
That is correct. I just want to say we wanted to present it to you to be sure that you didn't have an ethical issue with this type of marketing or with this separate but equal course strategy.
Because we don't really tell them how they can market these classes.
Except that they can't
I'm
market
okay.
before it's approved, but that's the only thing that we do tell them, they can't market
Okay.
before.
So let's see if I've got this right. So there's a school, D&D School of Real Estate, that's got a whole bunch of different courses they offer. Traditionally, schools like that have one core class. They're going to offer two core classes organized differently but covering the same material.
Correct, through two different
And that's
providers.
So Hondros, what is Hondros?
It's a provider, so they put together courses for, I think all of theirs are internet. I don't think they have any that
Internet
aren't.
distance.
Right.
Right.
So is the provider of the course Hondros or is it D&D School of Real Estate?
The primary provider is Hondros. They're the ones who actually have the course, and usually one of their individuals is the person that you see talking on the webinar or the, the internet course. And then under them is a secondary provider, and that's the D&D school. So that if you are a licensee and you go online to look up, say, the Trek Core, then you would see D&D listed as the provider of this Hondros course, and D&D would be responsible for turning in the roster and making sure that the individuals were there in class and doing all those things that are required of that particular provider. And that's the person that you as a licensee would be having your contact with.
And then separately, you would see, if it's approved, that he would have the same course under Dearborn. And they're both distance providers, both internet distance providers.
But I
given
bet
that-
more than likely, he's not going to market this, or D&D is not going to market this as you can choose this Trek course or you can choose this Trek course. They're just going to have Trek course.
I think he's going to bundle them differently so that, maybe one would be bundled at 15 hours, I don't know, 16 hours, and
something
one would
else,
be
yeah.
bundled at 10 with something else that might, a grouping that might appeal to somebody else. And I think it's a matter of the cost. I think there's a cost factor in there somewhere
We have
that,
a motion
I
on
don't
the
know.
floor to table it that we need to.
Okay, so assuming, Commissioner Bloom, you made a motion, did you? Or did you just?
Oh, it was just a suggestion.
Okay, so there is no motion on the floor at this point.
I'd like to make a motion, we approve it. Second.
And specifically, we're approving the
Yeah, as
Dearborn
written.
Kaplan course?
Yeah.
Okay. The motion's
It
on the.
doesn't have a number.
Yep. That motion's on the floor. Is there further discussion? Let's vote. Those in favor say aye.
Aye.
Those opposed, no.
No.
I have a 4 aye and 1 no vote. That motion is approved. Mr.
Thank you, Mr.
White.
Chairman. And continuing on, the number for that course then will be, in consideration of the add-on, was 836. That'll be 837. The next matter is Home Buying Consultants Real Estate Institute with contact person Reginald Payton. This is a school provider in Memphis, and they're requesting that a 40-hour concourse online training that he and his Miss Lewis, who is a formerly approved instructor, have taken, and they are professors in Memphis at Christian Brothers. They're wanting to substitute that course that they've taken, this online training that allows them to teach adults regarding online training, that would satisfy the Commission's and Arello's current internet requirement, and that current internet requirement is that they have the CDIC certificate, Certificate of Distance Instructor Education. Heretofore, of course, I'm new at this, but I understand the requirement is, and I have seen in other instances with other schools, that those instructors have the CDEI, without which we I can't put them on the listing for the agenda until they provide that. So with other schools, we've requested that and been provided that, but they're saying, would you consider, in lieu of our 40-hour training that we've already had that allows us to do essentially the same thing. They do have an Arello as far as approval, but they don't have the course approval, but they don't have the instructor approval through Arello.
So are we here at this point to consider approving the course or approving the instructors?
Well, it's a bit of both in that I wanted to bring it to the Commission's attention because I don't think I can offer the course for approval until the Commission decides that they will accept their training, which they purport to have had, in lieu of the CDIC certificate, which we're requiring on others. This would be, at least to my knowledge, something, a variance from the norm.
I move that we not approve that.
Second?
I just want, Arello won't approve a course that doesn't have an IDEC instructor. So if they unless they were to accept that, they wouldn't have an Arello approved course. I mean, and I don't think Arello's pretty, I mean, they're pretty firm that you have to have that IDEC instructor, and it's a pretty big certification process.
Consider changing your motion to approve it subject to Arello certifying the course?
They don't meet the guidelines, so
Well, then that won't, it's a positive motion is all I'm suggesting.
it's not my motion, so.
I just thought I'd bring it up.
If you vote yes, then that's positive, isn't it?
We're positive we
All
don't
right,
want to approve it.
the
right?
motion on the floor is to not approve Home Buying Consultants Real Estate Institute's request for a core class. We got a motion and a second, is there discussion? Let's vote. Those in favor say aye.
Aye.
Those opposed, no. The motion passes, the course is not approved.
Thank you, Mr. Chairman, members of the commission. That would conclude my educational report.
What about
Instructors.
instructors?
Again, forgive me, we do, I would like to submit the instructors on the agenda. Again, some are previously approved and some do need approval, including Mr. Ahmad Lewis with our own TREC office, as are contained in A1 through A37.
Mr. White, we used to, when, in the past, get a list of the instructors and what their qualifications were so that we could kind of look and see if they're qualified to teach those courses. So without that, we just have to ask you, have you reviewed all of these people's qualifications and they meet the guidelines as set by TREC?
Yes, Commissioner.
And it's not number 28 the same as 36?
It's 2 hours instead of 3.
Or one's two?
I got it.
Commissioner, one is the 3 hour versus the 2 hour.
Okay, so Ahmad wouldn't need to be on A28 then?
Not necessarily.
Okay.
Motion to improve the instructors.
Second.
To approve.
Okay, I have a motion by Commissioner Chara, seconded by Commissioner Franks, that staff's recommendation be approved and these instructors be certified. Making that stuff up as I go. So, any discussion on the motion?
Well, I do have a question.
All right, Mr. Bloom.
Timothy Howe, all his courses reference realtors. Like we're going to teach realtors how to read legal description. We're going to teach realtors. I don't think the commission should be involved in approving that category. I think it should be licensees.
That's right.
I think we can, in the past, I don't know if these are in his title or if it's in his description, but we have written a letter to the individual instructor, the provider, and, told them that you just need to say real estate licensees as opposed to limiting it to realtors, because the courses do
Can we
have to
do
be
that for
offered.
Mr. Howe?
Yes.
Absolutely.
Okay, thank you.
I think it's just nomenclature
Yeah.
with him.
That's something important he needs to know, though, if he's going to be teaching.
I have a question on course A10. It seems to me in the past, this instructor, Austin McMullen, Esquire, we've approved him previously. Does that not roll forward? Is it per class? How does that work?
He needs to be approved twice.
Okay. It's still in that probation period? Okay. All right, y'all have heard the motion. It's to approve these guys and ladies. If you're in favor, you'll vote aye. If you're opposed, you'll vote no. All in favor, vote aye.
Aye.
Those opposed, no. The motion carries unanimously.
Abstain.
Mr.
Esquire abstains.
I heard it. Let's make it a
Again, Mr. Chairman.
4 aye, 1 abstention vote.
Members of the commission, thank you for this April report.
Thank you,
And
Ross.
I conclude. Thank you, ma'am.
All right, Ben Wilson, you're here? Good. Would you and Tony Gaines come up, sit at this table over here where you can share a microphone? Now, I will tell the audience we'll have a couple of these today, but occasionally people in the process of trying to get licensed to sell real estate in the state of Tennessee need to disclose something in their past that makes the license process slow down or stop until they come before us. And that's the case with Mr. Gaines and his principal broker, Ben Wilson. Ms. Maxwell, can you read a narrative of what you know
Do you
about
want to swear them in?
I'm sorry, Julie.
Would you all raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
The applicant today is Tony A. Gaines Jr., and I don't know which one there. And the principal broker is Benjamin C. Ben Wilson, who holds license number 289414. He is the principal broker of Team Wilson Real Estate Partners, LLC, number 262304. Mr. Wilson was first licensed as a affiliate broker on 10/6 of 2003 and was first licensed as a broker on 8/14/2013. Mr. Wilson became the principal broker of Team Wilson Real Estate Partners, LLC, as of 2/14/2013. The track records reflect that Team Wilson Real Estate Partners currently has 10 affiliate brokers and no brokers other than the principal broker. Mr. Wilson has not had any complaints filed against him by the Commission. Tony A. Gaines Jr. has not yet taken the exams for licensure, but has submitted an application for preliminary decision regarding prior criminal convictions and or disciplinary sanctions and plans to pursue his real estate affiliate broker license if approved by the Commission to move forward with the licensure process. Mr. Gaines disclosed the following in his application for preliminary decision. On 7/12 of 2013, Mr. Gaines entered into a consent order with the State of Tennessee Board for Licensing Contractors, agreeing to a voluntary surrender of his contractor's license, along with all renewal rights, as a result of, quote, the accounting firm that reviewed the 2011 financial statements had asked to retract the previously reviewed statements from the Board due to the review of the statements being incorrect and or incomplete due to respondents, Mr. Gaines' falsification of bank records, end quote. Mr. Gaines stated that the financial situation described above arose as a result of a silent partner who invested in his construction firm in 2009. According to Mr. Gaines, the silent partner was to invest capital in the business in return for a percentage of the profits, but there was no written agreement apparently outlining the responsibilities and obligations of the parties. At the end of the fiscal year 2011, the construction firm broke even, and the silent partner decided to get out of the arrangement, and by doing so, removed the majority of the capital from the business. Prior to the withdrawal of the silent partner, Mr. Gaines stated that the financials had been submitted to the CPA for review so that the reviewed financials could be turned in for a renewal of his contractor's license. After several attempts to locate other investors, Mr. Gaines stated that he notified the CPA of the lost investor and lost capital, and the CPA at that point decided to retract his financial review. Mr. Gaines states that due to the firm's financial instability, he determined that it was in the best interest of all parties to surrender the contract license and close the firm. Mr. Gaines also disclosed a conviction for 2 misdemeanors in 2006, one for assault and one for resisting arrest. And Mr. Gaines states those both stemmed from a night of drinking, which resulted in a series of bad judgments, culminating in the charges and convictions. Over the last several years, Mr. Gaines has worked in various capacities in the construction industry, ranging from project manager to president to director of construction. Mr. Gaines believes that he will be an asset to the real estate profession if he is approved by this commission to move forward with his affiliate broker licensure process. And then you can add, if you'd like to add other information.
Yes, ma'am. Well, I was only convicted of one misdemeanor, and that was simple assault. My father-in-law was convicted of the resisting arrest.
Please move closer to the microphone.
Okay, now I'm confused. Switch or switch?
Yeah, this is the applicant, Mr. Gaines.
Tony Gaines.
Okay.
And his
Okay.
broker is Mr. Wilson.
Okay.
Okay, so why don't you just give us as much as you want to. You can repeat what Ms. Maxwell said, but we'd like to hear from you as well.
Okay. Well, first of all, number one, I was only convicted of one misdemeanor, and that was a simple assault. my father-in-law was convicted of the resisting arrest, and I included that documentation in the paperwork that I submitted so that you would see that it was two parties there. What the commissioner said was absolutely correct. As far as the financial instability of the company, I'd reached out and had a silent partner from the state of Georgia invest in my commercial construction company, and with nothing but a verbal agreement in place. And in doing so, invested a little over $1 million and provided us with bank statements, and that we provided further to our CPA. After we broke even, didn't have any profits to submit to the silent partner, the partner decided to remove his assets from the company, which then made our renewal basically void. So I contacted the CPA and let them know that we had lost the majority of our capital and they needed to resubmit to the state. And that's when the license were surrendered at that time.
Questions?
So you surrendered the license, or it was revoked?
Surrendered. Voluntary surrendered.
Okay, and so you were after this happened, you've been a project manager, a president of a company, and a director of a company, is that correct?
After this happened, I've been a construction manager and a director of construction.
For what company?
The first one was the construction manager was with Lennar, and Dream Home Construction, I was director of construction.
Is that single-family residential or
Yes, sir.
commercial? Single-family?
Yes, sir, single-family residential.
And you're doing that now?
No, not now. Currently, I'm just consulting with Team Wilson on some rehabs, just taking some subs in and letting them paint and things like that.
Other questions for the applicant?
Mr. Gaines, I had a couple of questions about the issues with the financial statements that you mentioned. What was I didn't see it mentioned, but what was the issue with Great American Insurance Company with respect to that issue?
The issue with Great American Insurance Company, once the capital was removed from the company, we had to notify Great Americans because they held our bonding. Once we notified bonding, they removed their bonding and took over our several of the commercial construction projects.
Okay. When did, let's see, when did the partner, I don't see the partner's name, but when did the partner decide to pull out of the business?
I guess it was February 2012.
Okay. Well, didn't the issue with the Great American Insurance Company have to do with how much money was in the account in 2009?
No, it was 2012 when Great American took over our projects.
Okay. Well, but the issue that they were raising about the statements that had been provided to them, didn't those have to do with how much money was in your account at First American in 2009?
I believe so, yes.
Okay.
It did, but TG Constructors, my construction company, wasn't the company placing the money in the bank. It was actually the silent partner from Georgia.
Okay. So there was some issue, though, about like where you had said there was $500,000 in the account, and they said there was $100 in the account. Can you explain that to me?
Yeah, the issue is we received a line of credit from our investor that placed in the bank, and he sent us a statement saying that there was $500. We called, verified that, and currently to have that bank account open, I had $500 in the bank account,
Okay.
which would have made it $505,000, or $500,500, yes.
Right.
And ultimately, the partner that submitted to the line of credit, it was a falsification line of credit statement. So when we called and verified, we were told misleading information that we prepared our financials on.
So when you were trying to find out how much was in the account, who was it that you called to verify that information?
It was United, I want to say United Incorporations out of Nevada is the institution that was holding the money from our private investor.
Okay. And they told you that the money was there? Is that what you're saying?
Yes, sir.
and that information was not correct.
That's correct. And we didn't find that out until Great American done further investigation.
Okay. I was going to ask you about one other thing. What is the Bunganut Pig?
That was a small restaurant pub that went into a partnership. I was more of a silent partner that just invested some money. It was a small restaurant in Murfreesboro.
Okay. What happened with the Alcoholic Beverage Commission or the illegal gambling device investigation with that?
Nothing ever happened with it. They couldn't. It actually didn't exist. That was just a statement that they had made from one of our competitors that said that we were having illegal gambling in our establishment, and so we got investigated, and nothing ever happened with it. And a matter of fact, I wasn't even aware of that. Like I said, I was just a financial partner in that business and had no involvement, or actually I only went to the place twice. And
Were there ever
aware.
any charges that actually came out of that investigation?
No, there was no charges.
Okay.
There was no bank fraud for those financial statements sent to bank?
No, ma'am.
Other questions? How long have you lived at Mount Juliet?
I've lived in Mount Juliet this will be my 10th year.
And before that, where did you live?
Before that, I was in college. I've lived in Murfreesboro. I've lived in Bowling Green, and originally from Greenbrier in Robertson County.
All right, Mr. Wilson, would you tell us a little bit about your company and why you think Tony might make a good licensee to fill
Yeah,
it with
I've
you?
known Tony for right at 6 years, and up until about 3 months ago, it was just purely on a friendship level. It started off, I met him the first time he came to a couple life group events with our church, which was held at our house, and then that relationship through a couple of other relationships just continued to grow. About 3 months ago, he came to me, him and his wife came to me and wanted to inquire about getting into real estate. And so we've had a lot of tough conversations about what it takes to be a realtor and things of that nature. And so as far as Tony's concerned, I think that he's made a lot of mistakes in his past. But just like a lot of us, people get a chance to learn from those mistakes. And that usually, if they're taught and if they're held accountable to those actions, that's a great opportunity for them to move forward.
So what about your company? How will you fit in?
Sure. So with our company, we represent about 14 different investors. And one of the things with Tony's background, he has an opportunity with his construction knowledge to help us find properties on how to improve those properties, remodel, potentially build. He won't be in any sort of building capacity with us. He will be helping us find those properties for the investors. That's probably the major way I see he would be an asset to our company.
Questions? Motion?
Mr. Chairman?
Yes, sir.
If I could, I'd like to make a motion that we defer consideration on this for 1 month, and in that month, ask Ms. Kropp if she could look into the issues with the TG Constructors bankruptcy and the Great American Insurance Company issues, just to confirm the information that we've been provided by Mr. Gaines this morning, as well as just see if anything came out of the issues with the restaurant in Murfreesboro, and report back to us on that next month, and we can make a decision at that time.
You've heard the motion. Is there a second?
I'll second it.
Okay, second by Commissioner Franks. Now discussion on the motion. Ms. Kropp, do you understand the request? You'll need to scoot up.
I'll figure it out. I've never had I don't know exactly what I need to look for, but I'll look in.
And
to getting what I
Austin can speak with her, right?
Yes,
Absolutely.
yes.
Okay.
Yeah, absolutely. All right.
Are you requesting Mr. Gaines to come back at the next meeting, or we'll just make a decision?
I think it's optional as to whether he wants to come back at that time. I think we can make a decision without him, but if there's additional information that Ms. Kropp gets and he wants to respond to that, I certainly have no problem with that. But I think if the report comes back clear, then I wouldn't say that he needs to be here It's optional for him.
We're gonna be in Bartlett next month anyhow. So
Okay.
He's in Mount Juliet.
Yeah.
Yeah, so he would not have to come to Memphis
So
for
it's-
that meeting.
Yeah.
So in an ideal world, Ms. Crop could research this and
Maybe have him call in if he wanted to.
Yeah.
Because he needs to be
Because he
able to
might
speak
want to
to it.
respond
Sure,
or whatever,
yeah.
but we could maybe make arrangements for him to call in.
Yeah.
Well, you don't have to come to Bartlett.
Yeah. Yeah. And if Ms. Crop has questions, during her investigation, I don't see any problem with her contacting Mr. Gaines, just if she needs follow-up information or anything like that in between now and the next meeting.
And even further, if she reports back within a couple of weeks that everything is fine, we could let Mr. Gaines know that as well, and then it'll just be a formality as far as approving this request at the next month's meeting.
Yeah, I would agree on that.
Okay. All right, you all have heard the motion. Are there any questions or further discussion? Gentlemen, do you have questions? You understand? All right, let's vote. Those in favor of the motion to defer for 30 days, say aye.
Aye.
Those opposed, no. That motion passes unanimously. Probably, I guess we already have your contact information, do we? Okay, so in case Ms. Crop, our lawyer, is that what you are, Julie, our lawyer?
She is.
Lawyer.
Esquire.
Lawyer, Esquire.
Oh, yeah, Julie Crop Esquire. But
Okay.
hopefully we'll get this wrapped up quickly. Thanks, men. Thanks for coming in.
Thank you.
Okay.
I could do the legislative update and the consent order log if you all wanted
Let's
to.
do that.
And there's two initial matters on the legal report that are kind
You're
of.
gonna have to-
There's two, I thought it was lit up. There's two initial matters on the legal report that are kind of represent separate matters from the others. So if we have time, we could handle those two and just move on to the new matters. Just let me know what you all want.
Just go for it, girl.
Okay, I'll start with the other two things, and then if there's time, we can do the first two on the legal report. All right, as far as legislative update, there's no information on your iPads. This is just, I pulled the 10-track information on any bills that might be affecting you all to just give you an update on kind of how they're progressing. And it looks like the only thing that we have any kind of movement on since February is that Senate Bill 145, House Bill 248, which involves legislation where a course could be approved for 1 hour in length versus 2. We were discussing it earlier. And that has been sent to the governor's office for signature. That was on 3/26, but we don't have where it's actually signed yet. I expect that that'll be forthcoming, and that'll be an update you'll be getting next month. But that's really the only movement since the last meeting that I could see. And the consent order log is on your iPads. It's just my tracking mechanism that Jenica and I maintain, just to let you all know that the consent orders that you've authorized have been moved on along, drafted, sent out. When someone accepts them, I move them to the closed sheet, and you'll see that that one's sort of colorful. That's where we monitor who needs to attend a meeting, who has attended a meeting, who hasn't attended it within the 180 days, so that we can be sure that all terms of those orders are fulfilled. So this is really just a tracking mechanism that I provide to you all at each meeting. If you have questions, please let me know, but really just to let you know that what you're authorizing is moving through the process.
What is FTS?
Failure to supervise.
Okay.
I'm sorry. If you want to know what any of the other
Oh, that's all.
abbreviations are, I'd be happy to let you know. Again, they're kind of shorthand so that we just kind of know the nature of them when we look at them. FTR is failure to respond.
So, just, my pet peeve, back earlier today, we showed under penalties or fines paid, like 2.5 pages of different licensees who have paid a fine for some particular reason. I think it would be helpful to the sphere of licensees for what those fines were for, and maybe even who the people were that had to pay them, to be published somewhere. Is that going to happen?
These ones, like in the disciplinary action that you see listed here, These were in March, so they've not been posted to our website yet. The department at the end of the month compiles all of these from the different boards and commissions. They are posted on the state's website, and there is a link on the TREC website at the top where it says TREC Disciplinary Actions. If you click that, it takes to a page where you can review all the past disciplinary action reports.
When I do that, I swear when I do that, like I saw this list today and it's 2.5 pages, but there are about 10 maybe that make it to that page on the website.
Well, there should be a longer, what I'm saying is this one has not been posted yet because this is for the month of March. Because yesterday was just the last day of the month. Anything technically that came into us through the close of business yesterday, which if something arrived at 4:30, it probably wouldn't have been on this draft here. This has not been finalized. The March one has not been posted yet. Some months they're longer than others. This will be a longer section, but the March disciplinary action report has not been posted online yet. Some months we get back to, some months we have a longer report. So these are taken from Ms. Smith. She sends them to a paralegal in the legal department. They compile it onto one large list. I then finally review it, and then it's posted to the website. So this information will be going on the March report.
Oh, is there, I don't see a reason why we shouldn't start.
Well, she said she's got two that she
I've got two that are kind of
added.
represent type issues.
Let's start with those,
And
then.
they're a little bit different than just completely new matters. And, one of them may require a little more discussion. And so we could at least start with those.
Let me advise the audience that we're to a portion in our agenda, because we're moving a little quicker than we thought we would, where the law department will present complaints that have been filed with the Real Estate Commission to us. And they have made those complaints anonymous in every sense of the word. We don't know where the complaint's coming from, who the people are, whether they're male or female. Julie will read those to us. We've been provided, in most cases, advanced copy of them. She will make a recommendation on what should happen with the complaint. And let's say the recommendation is for the respondent to pay $1,000 and come to one of these meetings. At that point, it will only be an offer to the respondent. And so if you hear a case today where this commission says, okay, if that respondent will pay $500 and attend a full real estate commission meeting, we'll settle it. Some of you might be here today because that was presented to you and you decided to settle it. You didn't have to. You could say, I want to have a formal hearing in front of the Real Estate Commission, which we typically have on our second day here in Nashville. We don't have it tomorrow. That's why we're going to have a one-day session today. So as you listen to these are complaints that have been filed with the Real Estate Commission by somebody. We don't even know who filed them in most cases, except for the failure to supervise complaints. And this commission has taken a strong position that if a complaint is filed against a licensee, then perhaps a complaint should be filed against that licensee's principal broker for failure to supervise. Doesn't mean they're guilty, or guilty is not the right word, is it? Is that the right word, Julie?
I guess guilty or culpable of the
Culpable,
violation.
that's the word I like, culpable. So as we go through these today, some are against the principal broker for failure to supervise, but all of them are anonymous. If any of us on this commission happen to know about a particular complaint, we have to recuse ourselves, which means, and we tell people when they call us that before one of these meetings they want to talk to us about it. Well, if they want to talk to us about it, we might agree to talk to them, but we tell them first we can't vote. If we have knowledge of the complaint, we're off the case. So, Julie, the first one you're going to read is a old issue, or?
Yeah, we've had some additional developments that have occurred since you first heard it. Something that this one's different than one you've ever seen before a little bit, and it was not on the original. Yes,
And it's not in our legal report.
it is on the one on your iPads.
Okay.
When you got the drafted one sent to you before the meeting, this one was not included on that report. But I'll read slower and explain it more if necessary, and I don't think it's anything.
What number?
It's just the first one on the first page. You've got the updated, finalized report here. It just has a little bit more on it than the draft that you received before. Any consent order authorized by the commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. The first matter is 2014-020-471, and this was originally presented at the February 2015 meeting. This complaint was opened by the staff of the Tennessee Real Estate Commission after receiving information from the Virginia Department of Records. Respondent pled guilty to a misdemeanor larceny on or about May 16, 2013, and did not disclose the conviction upon renewal of respondent's license on February 14, 2014. Respondent states that the misdemeanor charge was reported to a neighboring state while attempting to obtain a broker's license in that state. Respondent states that the neighboring state held a fact-finding conference regarding the charge and granted respondent licensure in that state. Respondent is remorseful that respondent did not disclose this information to TREC and states that respondent did not know it was required but has since read the code and takes full responsibility for the mistake. Respondent also attached a summary of the fact-finding conference, which concludes by stating it does not appear that the convictions involved the profession of real estate, and it appears that respondent's current Tennessee employer is aware of the criminal background. In consideration of respondent's criminal history and conduct and work activity following the incident, the board approved respondent's application for licensure. Character references were also included in the response. At that time, a consent order for $2,000 for failing to report a larceny conviction in violation of 6213 312B12 and 6213 312F plus attendance at a commission meeting was recommended, and the commission voted to accept the recommendation of legal counsel. Respondent signed and returned the authorized consent order with payment. Upon receipt, legal counsel reviewed the information to determine that an error was made on initial presentation. Tennessee Code Annotated Section 6213 312F does not provide the commission with discretion to offer a consent order. Instead, it mandates automatic revocation when proper notification is not made to the commission, which was not done here. This was confirmed with the Deputy General Counsel. Therefore, the consent order was returned to respondent with a refund of payment, and respondent was notified of the automatic revocation of respondent's license. Because TCA Section 6213 312F mandates automatic revocation, it is recommended that the commission rescind the previously authorized consent order by motion, and therefore the recommendation is to rescind the previously authorized consent order and close this complaint.
So moved.
Second.
A motion by Commissioner DeChara, seconded by Commissioner McMullen, that our previous action be rescinded. The net effect of all of this is the licensee is no longer a licensee.
No, that person would be able to reapply with you all. They will have to come before you all as these other informal applicants have done today, just due to the nature of the conviction, with it being a conviction related to theft, even though it's not related to real estate in the past. At that point, you all can hear all the circumstances, decide that, you know, this is really not something that we think will affect the honesty, trustworthiness, and ability to conduct the business of broker, and you may all decide to reissue the license. But unfortunately, this statute just does not give me or you the latitude to say we're not doing it. It says it shall be automatically revoked when certain circumstances happen, and unfortunately, those circumstances happened here.
Other questions, comments? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Item 2.
Okay, 2014-026-241. This was presented at the March 2015 meeting. This respondent was the principal broker for a respondent that was presented above at that meeting. The matter was opened on a failure to supervise issue. As of the preparation, there was no response from the respondent, and the recommendation at that time was a consent order for $1,000 for failure to respond in violation of our statutes, which are noted in there in the recommendation. The commission voted to accept the recommendation of legal counsel. That consent order was sent. At the March 2015 meeting, the commission did dismiss the complaint, which was number 2014-026211, against the affiliate broker who was affiliated with this respondent, and the commission authorized this consent order for this respondent only due to failure to respond. When this respondent received the consent order, respondent contacted legal counsel by email with a scanned copy of the response and transaction file that the respondent mailed to the TREC office on October 26, 2014. Respondent asked for reconsideration in light of the fact that respondent submitted the response within the time requested in the complaint cover letter. Legal counsel reviewed the materials provided, and it appears to be a thorough response to the complaint for failure to supervise. It's legal counsel's opinion that this respondent is being truthful in having sent a response which somehow did not make it to the complaint file for review. Therefore, it is recommended that the commission discuss possible reconsideration of this consent order for failure to respond to a complaint.
Question.
Yes.
This isn't related to the person who had the theft conviction in Virginia.
No, it's not. And I'm sorry, I
Okay.
just always copy in the old
Okay.
summary so that you know exactly what you had when you considered this the first time. In the report last month, the affiliate broker whose complaint numbers referenced in this additional information was listed above it. I just didn't see any need to rehash all those facts because you all did not see a failure to supervise last month.
Okay, so basically, the council is coming to us and saying that in at least this rare case, council believes that the file should have been completed and the response should have been noted, but somehow it didn't make it to the appropriate desk.
This is the first time this has happened, to my knowledge,
I don't
too.
remember you ever asking this.
No, I've never had somebody say, I submitted it and here's my response I sent you. I've actually never had that. And to me, that's significant.
And this was while you were out on leave, probably, right?
No, it was submitted in October, but we have a delay in files because we just have a sheer number that it takes me a couple months to review it. I reviewed this last month. I looked through the file. We even checked with the staff. This response was in nobody's file. We always double check to make sure that it's not something that just didn't make it up to my floor from their floor. But I mean, things do happen with mail. The lady, this respondent said, you know, I didn't send in my response by certified mail. I guess I should have checked to make sure it was received. But we don't have a requirement that they have to send their response to us by certified mail. It appeared to me that it was just too quick for this original response to have been fabricated on the back end. It just was immediately after receipt, I was contacted with a full packet of documents. And it just,
So is the first question that we have to deal with whether we're going to reconsider it?
if you all aren't willing to do it, it's died for lack of motion before. If you all want to make a motion, I just am recommending,
But
you know.
if we make that motion and it passes, when would you then go and study the response and come back to us later with an actual analysis of whether there was adequate supervision?
Well, there was
Or-
no underlying violation found for the affiliate broker, and typically, I mean, I reviewed the response. It did not appear that there was a failure to supervise, but typically, I don't think we've ever had it. Not saying it couldn't happen, but we don't typically have a failure to supervise on the part of the principal broker when you all have found no wrongdoing by the affiliate.
So the reconsideration would really be just to wipe it out and everybody would and dismiss it, I guess. Is that
Just-
right?
Yeah, because the consent order was purely limited to the issue of failing to submit a response. That was all that was included in this consent order.
Mr. Chairman, my motion is that we reconsider the consent order and dismiss this, whatever case number this is.
Second.
All right, a motion by Commissioner McMullen, seconded by Commissioner Franks, is that right? That the previous consent order be rescinded and the complaint be dismissed. Is that good enough?
That's fine, if that's
So-
what you all
so-
want to do.
Is there discussion on the motion? All right, let's vote. Those in favor of that motion say aye. Aye. Those opposed, no. That motion passes unanimously. Do you have one more short one, Julie, before we take a break?
The next one is a little bit more lengthy, and it's an advertising issue that I
Okay.
imagine you all might want to discuss. So that's really, unless we took them out of order, that's really
good.
about.
We're going to take a break for lunch. We'll be back here at 1 o'clock Central Standard Time. We'll interrupt. I think we have another informal appearance at 1 o'clock, so please be back on time, and then we'll get back into the legal report. Enjoy your lunch. We're recessed. All right, ladies and gentlemen, we'll get started back. Just as a point of information, this commission is typically made up of 9 members, 3 from East Tennessee, 3 from Middle Tennessee, and 3 from West Tennessee. Today we have 5 members from Bartlett, Tennessee, which is Memphis. Is that close enough?
Close enough.
Where are you from, Janet?
Jackson.
Jackson.
West Tennessee.
West Tennessee. Marcia's from Franklin, she's told us that. And Austin is the only non-licensed member of the commission presently. And he's tied with the governor and must, and he's from, what is the name of that town, Austin?
Oak Hill.
Oak Hill. He's a former mayor of Oak Hill. And it's,
You're not, okay.
but he's still on the board. Are you alderman there, or what are you guys? Commissioner. So he's the commissioner in more than one place, which is,
Also an attorney.
we everybody could tell he was an attorney.
You know, you said he wasn't licensed, so I just.
He's licensed
What the
as an
heck's he doing
attorney.
here?
Right, yeah.
He's our esquire.
All right, so with that said, we've got it.
You're from Knoxville.
Oh, I'm from Knoxville, thank you.
Biographical interlude.
And we have 3 sick, not just 3.
We have one recovering from surgery, one sick from Bristol.
And one having a test today.
Who's that?
Grover.
Grover's having a test, okay.
And then one seat that's vacant.
Yeah, I knew that. All right, so here we go. We have our second informal applicant appearance of the day. James Dale Courtney, Charles A. Rogers. Is that the same as Tony Rogers, Charles A.? Gentlemen, if you'll come up here and have a seat. Split that microphone right there. We will record you and we need to hear you, so each have a seat. Ms. Maxwell, read. Do we swear him in? We have to swear him in again, don't we?
Will you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes. Truth. Thank you.
The applicant for affiliate broker's license is James Dale Courtney, and his principal broker is Charles A. Rogers, license number 235297. Mr. Rogers is the principal broker of Realty Executive Associates, Inc., number 255219, and Southeast Referral Associates, number 260801. Mr. Rogers became the PB of Realty Executives Associates, Inc., and Southeast Referral Associates, both located at the same physical address in Knoxville. He was first licensed as an affiliate broker on 9/21 of 1987 and was first licensed as a broker on 1/1 of 89. Finish that first sentence. He became the PB of Realty Executives on 4/23/1996 and of Southeast Referral Associates on 1/13 of 2009. The track records reflect that Realty Executives Associates, the firm with which Mr. Courtney wishes to affiliate, currently has 85 affiliate brokers and 11 brokers. Southeast Referral Associates currently has 8 affiliate brokers and 4 brokers. Mr. Rogers has not had any complaints filed against him by the Commission. James Dale Courtney has taken and passed the national and state exams and applied for licensure as an affiliate broker. He revealed the following in his application for licensure. On 1/15 of 1982, Mr. Courtney was convicted in the criminal court for Knox County, Tennessee, of 1 count attempt to commit the felony of obtaining personal property of another exceeding $200 in value by means of false pretenses, a felony. For this felony conviction, Mr. Courtney was sentenced to 1 to 3 years in jail, but the court found that he was a, quote, proper person, unquote, for probation and therefore suspended his sentence and placed him on probation for a period of 3 years, expiring 1/14 of 1985. Mr. Courtney also had to pay restitution. Mr. Courtney completed all the requirements ordered by the court, and his probation expired as directed by the court on 1/14 of 1985. Mr. Courtney states that 35 years ago when the incident occurred, he owned a boat for which the bank had loaned him money. Mr. Courtney's conviction was the result of his agreeing to go along with his friend's suggestion that Mr. Courtney act as if the boat were stolen and file for insurance. The friend said that this would allow Mr. Courtney to sell him the boat for less than the financed amount, with the insurance proceeds paying off the bank loan on the boat with money to spare. It turned out that the friend was a police officer. Mr. Courtney states that he never turned in a claim to the insurance company on the alleged stolen boat, which is why the conviction was an attempt to commit rather than the actual commission of the crime. Over the last 30 years, Mr. Courtney has been a businessman and involved in sales and looks forward to continuing his career as a real estate professional.
All right, Mr. Courtney, in your own words, why don't you just tell us what Ms. Maxwell just said?
Well, she does it better than I can. Basically 35 years ago was when this happened, and I was more of a follower at that time than I was a leader. I ran around with the old saying, the wrong crowd. And a guy showed up in this crowd and picked me out for some reason and wanted to know if I wanted to sell my boat. And I said, no. He said, I'll give you $2,500 for it. And at the time I said no, and then he kept coming back and saying, well, you can turn it into your insurance company and collect more money. And I thought about it, and being excuse my language, stupid at the time, young, just divorced. I told him that I would go ahead and go along with it. Well, I turned it into the police, and I didn't ever turn it into the insurance company to collect any money. And I kept thinking, and he'd come back and say, have you turned it into the insurance company? I said, no, I'm not going to do this. I gave him his $2,500 back, and like the next day, they came and arrested me for an attempt to commit a fraud.
How were those next 3 years?
I really didn't. I didn't know anything that went on except I vaguely remember. But the only thing I know is I had to call them and maybe report once every 6 months or something, and that was it. I never heard back from them.
Okay, so I suspect this commission is more interested in on what's happened since January 14th, 1985. Tell us.
Well, since then, I've been married for 32 years. I have 5 children, 14 grandchildren. I'm a very devoted husband. I'm a regular church member. I've been on several mission trips since then. I know I was wrong, but it will, nothing like that has even come close to happening since. I made a mistake in my life, and I hope for forgiveness.
The commission.
What kind of sales have you been in? It's said that you've been in sales.
Yes, ma'am. I worked for Peterbilt of Knoxville for 36 years. I was sales manager. Since then, I've been in business for myself, buying and selling trucks.
Why do you want to be a realtor?
Buying and selling trucks is terrible right now. I've got most of my family is in the real estate business. I feel like that I could be very successful. I know that I'm a good, honest person now, and I don't want to quit work. And I've got myself in the position that really, I need to make some kind of, a little bit of money, but I mostly want to do it because I want to stay busy. But also, I carry around a burden on me that I want to be successful in anything that I attempt to do.
Other questions for Mr. Courtney? Mr. Rogers, why do you want this guy on your team? Use the microphone for us. We're recording this.
He's a great stand-up guy. I think he'd make a fine realtor, and he's a great example to his community, really. So, good fit for our company.
How long have you known him?
I've known him about 2 years.
What's your process with 85 affiliates and 11 brokers? Tell us a little bit about your how you handle that many realtors.
I have help from I have a good staff that we oversee all of their advertising, and if they have problems, we try to address the problems as they happen, and they're difficult, I can assure you, but we manage. All the signage is correct. And I have 3 good staff members that help me with that.
And are they licensed people?
One of them is, yes.
Okay, but you have the final say on your advertising?
Absolutely.
And total control of your escrow account?
Absolutely, yes.
What does your training program look like?
We have a lot of online training. We have in-house training. We have I do a lot of the training myself with technology, the dot loop and things like that. We have training, which is an online training. We offer that to all of our agents, which the agents to do the right thing.
I'd like to make a motion, we approve Mr. Courtney.
Second.
Okay, I have a motion and a second. I have a comment after we vote. Is there further discussion? Let's vote. Those in favor of the motion vote aye. Aye. Those opposed, no. Motion passes unanimously. You're free to pursue that career, this career. And two things. Tony, if one of our members who's not here today will tell you that if he comes back, you come back. So
I understand that.
It's more. It's as much on you as it is him.
Absolutely, I understand.
And that's for all 80-some-odd licensees that you have.
That's why I'm willing to take the risk.
And second of all, James, is it James Dale, or what do you go by, James?
Jim.
Jim. So one of the letters of recommendation you included in your package was from a fairly questionable fella, and I ignored that letter.
I know who you're talking about.
Well, I ignored that letter.
He happens
Otherwise,
to be married to my wife's sister.
Gary Kuntz is married to your wife's sister?
I'm afraid so.
You want
I'm
to
sorry. If I told you who my ex-wife was, you'd really pass that.
That's why I wanted to wait till after we voted, because otherwise it could have been. Well, gentlemen, thanks for coming down. Good luck to you.
Thank y'all very much.
Does
Thank
he
you.
need to sign in at the back? Back
No,
there?
no. You guys you're good to go.
Thank y'all.
Thanks.
Thank you very much.
Thank you.
All right, now, so we've got another member of the legal community here representing the Department of Commerce and Insurance in some form or fashion. Miss Robin Ryan is here to tell us something or ask us something.
First, I must tell you a story.
Not a joke, not a
Now, it's
joke.
not a joke. I was getting ready for this.
Well, let's get
and
you in front of
your-
that microphone.
And your legal counsel came in to say, I need your help, very much need your help. They have changed the system on our copier, and you have to do it by voice. It's voice activated now, and I can't get it to recognize me. And the commission has asked me for this information about the consent order log, and I need to get it to them. Would you please, because I have a Yankee voice, would you please come and talk to...
A Yankee voice.
Yeah.
told
Would
her
you
I was
please
having
come
trouble
over
with
to the
Southern
printer?
accents.
Went over to the printer, and yes, it says, here. It was Canon, it was everything, and it told you how to do it. I said, well, what do I do? She said, just say copy. So I went, copy! And then she started to laugh. I said, is this an April Fool's joke? She got in front of everybody.
Oh, that's pretty good. Way to go, Julie.
Nobody
She
deserves
is a
it more.
clever woman, smart and clever.
Well, thanks for sharing that story. It is kind of a highlight of the day so
Just
far.
beware of her.
If
She's
we get out
very
of here in
clever.
time, I'll go use that at my office too.
That's a good one, Julie.
And she really had me sold, honest to God. She was so worried about y'all. Okay, the matter that's here this morning, or this afternoon, that I'm bringing back to you is a case that was heard by an administrative law judge. I just want to give you a little history and background so you understand the process. And when an administrative law, and it was an unlicensed case, and when an administrative law judge has a hearing, their order is an initial order. And there's a number of procedures that can go on between then and even getting over the Chancery Court. Because ultimately, this commission has the ability to undo or redo or whatever that has been done by an ALJ. So if you didn't like an order, you could ask for it to be reheard. He filed a notice, several notices under the law. Actually, they were recognized as notices by the judge, the head judge over here at APD. And the most recent one was he went through the step for reconsideration, notice of a reconsideration, which was denied by the judge who heard it. Then he has filed an appeal. And I think you know this from the last time I was here before you on this matter. When an appeal is filed on the initial order, it is then up to the commission to determine, or the agency to determine whether they're going to hear it, deny it, et cetera. You assigned it to Mr. McMullen to review it. And it was determined at the meeting that he should have a certain amount of time to file a brief, and then I would have a certain amount of time to also file a response brief. He was served with that information. Let's see. I have it in my response. Hold on just a minute. It was sent on February 5th, giving him till March 5th to file a brief, and it was sent by regular mail and FedEx. And as of March 13th, and frankly, as of today, April 1st, there has been no brief filed or received. And the mail, no, the regular mail or the other mail has not been returned. So we must presume he did get a copy of it. The letter was from me outlining the process. What I am here today to ask, and it is before Mr. McMullen, I have sent the motion to dismiss the notice of appeal to him. What I'm asking today is to dismiss it. What would then happen is that the judge's order would become a final order. He still has the opportunity to file it in the Chancery Court if he so chooses. So it doesn't change that. But so I'm asking, please, I make a move to dismiss the notice of appeal based on what I have just relayed to you. I certainly would welcome you to discuss, since Mr. McMullen was assigned to, on your behalf, to be in charge of this. I would turn that over to him.
I think we should grant the motion. He had notice of the briefing deadline. He didn't submit anything. It's been almost another month. He still hasn't submitted anything. He's not prosecuting the appeal, and so it should be dismissed.
Is that your motion?
It is. Sure.
Can he make it?
Sure.
Since
That's
he
my
was the one
motion.
on this case?
Move to dismiss for lack
Second.
of prosecution.
All right, is there discussion on the motion? All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
I believe that this order then would be dismissing it would be for your signature as the chairman. And at that point, the judge's initial order will become final, and then at that point, he has the opportunity to file with the Chancery Court.
Yeah, don't go anywhere. This is no April Fool's joke. Tell the audience what the amount of the judgment was.
Oh. 260.
An administrative law judge found a non-licensed person guilty of something and fined him
Practicing law,
Licensed
practicing
activity.
that law.
practicing real estate without license,
Unlicensed
Yeah,
activity.
unlicensed activity.
$260,000 fine.
Actually, maybe, 260, 290. 290. 290.
It's the biggest fine I've ever heard.
Me too. It's a penalty.
A penalty, I'm sorry, civil penalty.
What happens if he doesn't pay that?
Well, what will happen is, ultimately, when the appeal time has been resolved and there's no opportunity for an appeal, and he is still not satisfied any terms of the final order once it's been filed, it would then be placed with collection, well, are you doing that?
AG's office.
Attorney General, because it's a large one, it's over $10,000. Then the Attorney General then makes attempt to do it by collection.
Jeez. Property management, right?
Was property management, sorry. I
Property
can't remember.
management without a license.
It was at one where the judge, we had a certain number of days so the judge could
She did it by
see that.
days.
She did it by days.
$1,000 a day, is that right?
She could, but she did 500, I believe,
She
a
did
day.
500 a
Yeah,
day.
she could have done
Up to
1,000.
5,000. It is not what I do want you to know that it's not what I asked for, but
You don't know.
Probably were nicer than that, weren't you?
I didn't ask for anything. Oh, yes, of course I was nicer than that.
So it would have behooved that person to answer the, I would think it'd give him a
They
few
answered
more
the
days.
complaint.
Yeah.
Oh,
But-
no, the consent order, she said.
Yeah, it would have behooved him to sign the consent order. That's correct. Which the moral of the story is, if you get a consent order, let me explain this. Do you mind if I explain it?
Use
to
the
you?
microphone.
Use the
Do you
microphone.
mind? If a licensee gets a consent order, you may have an opportunity to agree or disagree with it. If you disagree with it, it goes into the litigation process. When it's in the litigation process, the litigation attorney does not have authority to negotiate except for in rare, very rare circumstances, which means there will be a full hearing. Once it has been filed with the APD office, which is the Administrative Procedures Division, which is the Administrative Law Judge's office, there is immediately a $200 filing fee. If it goes to a full hearing, you can expect that the court costs will be anywhere from $500 to maybe even $2,000, depending how long. So, if you're absolutely confident you've done nothing wrong, that's one thing. If you're hesitant at all, that's another, because it can be way more expensive. I'm not trying to scare you off, I'm just wanting you to understand the process. It's not an easy process.
Maybe the scariest part of it is many times Miss Ryan is carrying the state's case, and she acts mean a lot of times. And she hates to lose, I've noticed over the
Yeah,
years, too.
I do hate to lose.
I've not seen her lose.
Oh, well, you don't want to, but
No.
every once in a while.
that's not pretty.
I generally don't lose.
All right, any other comments, Ms. Ryan?
No.
Thank you for
Yep.
coming down out of your tower or
Thank
wherever
you.
you go and
Go back
seeing
up
us.
to your pedestal, your penthouse.
All right, we're back now on the legal report. As you may recall, Ms. Ryan is reading into the record circumstances and making a recommendation.
Oh, Ms. Crop is reading.
I'm sorry, Ms. Crop, excuse me. I would have gotten that myself if you would have just given me a second. So,
You act like a wife.
generally speaking, we don't have nearly as many this month as we normally do. Is that a fair statement?
I'm sorry, what?
We don't have as many cases as we normally do.
Over the past couple months,
Yeah.
it's less, but this used to be more the norm, but it's half of what it was last month. Ready?
What are we on, number 3?
Does everybody have it up?
Yes, ma'am.
All right. 2014-026-181. A complaint was filed regarding respondent, Principal Brokers, advertising. A photo was included of a sign which appears to have been below a yard sign. Said sign advertises a giveaway to win $100,000 towards your dream home. Further, respondent's website was printed on September 12, 2014, and the phone number advertised on each page of the website is not the firm number listed with TREC. Further, there is a page on the website entitled Agents, but the other 2 individuals listed are not licensees. Respondent states that the proper disclosures were on the bottom of the sign, which discloses no purchase necessary. A purchase will not increase your chances of winning. Legal residents of the 50 United States, D.C., 21 years and older, void where prohibited. Sweepstakes ends 1/31/15 for official rules, prize descriptions, and odds disclosure. How to enter without pre-qualifying for a mortgage, visit, and it included a website URL. A close-up photo of the sign and a copy of the official rules were provided by respondent. Regarding the website, respondent states that respondent changed the website design in August 2014, but the servers were maliciously hacked on August 19th, and the site reverted back to the older design. Respondent states that respondent was not aware that the sign had changed back to the default until mid-September, and the screenshot of the site in the complaint was taken during the time the old site had reverted. Respondent included email correspondence with the server host corroborating the timeline of events. Respondent states that other issues were corrected as soon as it was brought to respondent's attention, but the changes were initially made without respondent's knowledge or permission. Office of Legal Counsel followed up and reviewed the website on March 18, 2015. The firm's phone number is now found on every page of the website. The agent's page has been edited to say, Meet the Team. One of the individuals listed has the title of Expert Buying Advisor and the other Client Services Manager. It is legal counsel's opinion that the disclosure on respondent's sign discloses all pertinent details on the face of such offer or advertisement and does not appear to be a violation of 1260-02-.125B. However, it does appear that respondent's website for at least a month did not contain the firm telephone number as required by 1260-02.122B and 4A. Further, the page entitled Agents, which contained photos and names of unlicensed individuals, appears to be misleading advertising in violation of 1260-02.122E. It appears that respondent has corrected these issues, but respondent admits this information existed on the website for approximately a month before respondent, who is a principal broker, noticed that the site had reverted to an old design. The recommendation is a consent order in the amount of $500 for violation of TCA Section 6213-312B14 and Rule 1260-02-.12, highlighting 2B that says the firm name and telephone number must be on all advertising. 4A, firm name and phone number must appear on each page of the website. And 2E, prohibiting advertising in a false, misleading, or deceptive manner, plus attendance by respondent at one entire regularly scheduled meeting of the Commission within 180 days of respondent's execution of consent order.
Is there a motion?
Make a motion, we approve council's recommendation.
Second.
Seconded by Commissioner McMullen. All right, the floor is open for discussion. Ms. Franks.
I have a question, and we have not been able to discuss this, so I would like to ask. I've been working on my website and looking at other national company websites. And of course, if you're a national, I'll just say Coldwell Banker, just for, I can't remember if they had it or not, but some of the national companies, they don't have telephone numbers on, and that's their first page of that's the first page of every Coldwell Banker, and they don't have a telephone number. So, what are we going to do about? I mean, how do you? What do we do?
Did we try to address that, the rules that are proposed at this point?
Yeah. That's in those.
That was not the case here. This was an individual firm's website.
No, I'm not saying here,
Yeah, I mean,
but
it just.
since it's open, I wanted to ask while I could.
Well, I think I read
What's
the
the new
transcript.
rule say?
I wasn't present at that, but I did read through. Well, what does the current rule say?
Or, well,
When you all were talking about the proposed revisions to the rule, which have not gone into effect yet,
Right.
keep that in mind. These are still the proposed revisions, and those are at the AG's office, by the way, now. How did the question come up? It was with regard to.
You say licensee, and so that instead of individual.
I don't have my. Yeah, I don't have my my rule. I have a whole folder of my rulemaking materials, but as I recall, the revised rule, where it goes into the definition of what advertising will include in the first paragraph, it says, it's with regard to language in the new rule. I may have to look at Eve's notes. I'm sorry. I read the transcript, and you all had discussed it, and it was basically saying when you're limiting it to advertising that's done by a particular licensee or firm, it's one thing, but the national firm's website is another, where it was saying if you've got Coldwell Banker, to stick to your hypothetical, multi-state, large firm, their one central website would not need to list every single Coldwell Banker firm in Tennessee on it. But if you've got an individual one, say you're running one of the offices in Tennessee and you're the principal broker, you would want to make sure that on your particular firm's website, you have your own firm's name and license number on there. Am I explaining that as?
I think I have the original copy. I think that the motion that was made during the course of the discussion was that it would say, the language would read licensee, as opposed to any other thing that would be any other word that would encompass a broader group. So by narrowing it to licensee, it would then focus on the firm or the individuals who were actually licensed in Tennessee.
In our state.
And not include the larger group that, nationally. I think you had a question about it that involved the television advertising and what would happen, what would happen over the Super Bowl if a national company advertised?
Would they have to list all of the firms on the page really
and so
quickly?
then the language was changed to licensee to narrow it down to that particular.
so knowing that, are we now, if something comes in that's a complaint about a business, I know we're going by the rules now, and until that is, and who knows, that could be months, could be weeks, we don't know. But, so if we get a complaint in about that now, what are we doing? Are we just kind of holding off because we know the rule's going to change, or?
Well, right now, as our rule is currently written, the advertising rule is currently written right now. Subsection 4 of the advertising rule is just entitled Internet Advertising. For example, A says the listing firm name and telephone number must conspicuously appear on each page of the website. Right now, if it's a licensee that it's a website that it's under their control, as the current rule stands, you're supposed to have your firm name and telephone number on it. Also, up at 2A, which is for all advertising, this would be your signs, even, for example.
Click on a national and it doesn't have it, and then you can click on the state and it'll go to that, and so we just disregard that now, then, right?
We have not had a complaint where we've had that set of
Okay.
circumstances come up. Right now, it has
Okay.
all been with respect to a particular licensee's
Okay.
firm. So we've
Okay.
not had that situation come up yet. We typically confine things to the facts that are presented, and so we have not had that question yet. But that would be, I believe, something to consider. We're going by our rule as currently written right now.
Okay.
Does that answer your
Thank
question?
you, yes.
Okay, other comments
Sorry.
on the motion? That's fine.
And this matter was in the original draft that I sent to you all, as well as the one after it. And these are kind of similar, if you remember when you read it. And so I don't know if you want to hear both of them. I think there's a difference between the two, and I explained that. But I just wanted to point that out in case anybody hadn't had the opportunity.
I do have a comment. Is it legal to gamble in the state of Tennessee? Isn't this a gambling
I do not know the
exercise?
gaming laws particularly. I mean,
Well, the reason I ask, we were trying to do a thing for St. Jude, and they called that gambling, said we couldn't do it. This gentleman is offering tickets for $100,000. That's gambling in the state of Tennessee. It has nothing to do with our rules and regulations about advertising, but I think he's doing something he shouldn't be
I
doing.
don't think you have to purchase anything for this, though.
Yeah, you have to purchase a ticket.
Not for this particular
register.
subject.
Well, you
I think
just-
the elements of gambling in Tennessee are prize, consideration, and chance. And this one doesn't have consideration because it was free to enter.
You can just.
Oh, I thought you were buying.
I read into the detailed rules, you can either go to a website, sign up with your information, and a licensee will contact you. It says about possibly getting pre-qualified for mortgage. Although there's also another way to enter where you can just take a card. I think it's a 3x5 card, write your name, address, and telephone number on, mail it in, and be entered without having to enter.
Why would he give away $100,000 to buy a house?
This person is not actually doing, as I understand it, it's a group of people, and it's a promotion that different people can advertise, but this person's not the one actually giving it away.
Oh, nationwide.
Mm-hmm.
Probably have to have 4 billion people enter to make it work.
All right, other discussion.
Several buy a house.
Motion is to accept council's recommendation and offer a consent agreement that includes a $500 civil penalty and attendance at a 2-day meeting or a full meeting of the Tennessee Real Estate Commission.
I'd like to change that to a maximum, $1,000.
All right. So, Mr. Bloom has offered an amendment. Seconded by Ms. Franks, that the penalty be increased from $500 to $1,000 plus attendance at a real estate commission meeting within 180 days. Is there a discussion on the amended motion? All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Two things. First of all, council will now go to that licensee and say, here's a chance for us to get this thing settled, pay $1,000 and come to this meeting. They may and have every right to say, nope, I want to come and have a full-blown hearing down here. And so that will be the next step. Us on the commission won't know for maybe months what the outcome is. Number two, you've heard discussion about new rules that the Tennessee Real Estate Commission is proposing. There may be some who've been told those rules are in effect, and you may even have copies of them. You shouldn't, they're not. Okay? Those rules are at the Attorney General's office, and they have all kinds of latitude to change those and send them back to us. So don't go telling people or don't believe that those rules are in place. It's going to be 90 days after the AG says they're okay.
After we file them with the Secretary of State's office, when we receive approval from the Attorney General's office and they're reviewing them as to constitutionality, when they send them back to us signed by the Attorney General, I will then forward it to the Secretary of State's office. It will be filed on the administrative register on their website. We'll use our Notify app that any licensee that's signed up to receive email or text notifications, and a notification will go out. It'll be posted on our website. We'll probably notify all the associations. We try to get the word out as much as we can, and then from 90 days from that filing date is when the rules should be effective.
If the AG makes changes, do they come back to us?
I'll be bringing back if there's any substantive changes to the rules. I haven't been contacted. I mailed them on March 18th to the Attorney General's office, or they were hand delivered on March 18th to the Attorney General's office, and I was going to give them a couple more days before I followed up.
Thank you. All right, item 4.
2014026-191, a complaint was opened against Respondent Principal Broker regarding Respondent's firm Facebook page that was printed on September 8, 2014, which features as its photo and cover photo information which states, win $100,000 towards your dream home, $100,000, grand prize $10,000 biweekly $10,000 biweekly prizes. The Facebook page does not appear from the printout to have any disclosures. It appears that you can click on a link to Respondent's firm website where there is a box to register now, where an individual fills out his or her name and contact information. Below the registration box, there is a limited disclaimer language that states, no purchase necessary. Legal residents of the 50 United States, D.C., 21 years and older, ends 1/31/15. To enter for official rules, including odds and prize descriptions and how to enter without pre-qualifying for a mortgage, visit, and it includes a website URL. It appears from the printout that on the same page of Respondent's website, there's information explaining that if you fill out the contact form, an agent will contact you to take you through a pre-qualification process, and a link that states, for official rules, click here. Respondent states that the brokerage prides itself on professionalism, honesty, and integrity and would never intend to mislead clients or potential clients. Respondent states that over 200 real estate agents from across the nation partnered with a sponsoring company and mortgage company to pool money to have one massive give back. Respondent states that a name is drawn every 2 weeks for the giveaway. Respondent states that 17 $10,000 prizes are awarded and a grand prize of $100,000 is awarded. Respondent states that there is no cost to enter, and entry can either, 1, be mailed in with a name, address, telephone number, and email, or 2, through pre-qualification for a home if the contestant is seeking to purchase a home in the future. Respondent states that the prize money is awarded and the recipient can do whatever they wish with the prize, stating that one of the 8 prize winners so far has chosen to use the money for a down payment on a home, but the rest have used the money for other purposes. Respondent states there is no obligation to buy a house, use a real estate agent, or anything else. Respondent states because there is no cost, no obligation, and winners can choose how to spend their prize money, there is no inducement. In legal counsel's opinion, although there is no cost, obligation, and a choice in how prize money is spent, the TREC rule on offers and guarantees states any offer, guarantee, warranty, or the like made to induce an individual to enter into an agency relationship or contract must be made in writing and must disclose all pertinent details on the face of such offer or advertisement. This language says that the offer only has to be made to induce someone to enter into an agency relationship or contract. It does not require actual inducement. It seems difficult to believe that this advertisement was not made for the purpose of acquiring business for respondent's firm. Additionally, although there are disclosures on respondent's website about the giveaway, the Facebook page does not appear to have any disclosure language at all, differentiating this respondent's advertising from the previous respondent's advertising in legal counsel's opinion. Additionally, the Facebook page appears to be that of respondent's firm but does not include the firm name or telephone number anywhere on it, just a web address which links to a website for the firm. This appears to violate 1260-02-.122B, requiring the firm name and telephone number on all advertising, and 4A, requiring firm name and telephone number on each page of the website. The recommendation is a consent order in the amount of $500 for violation of TCA Section 6213.312B14 and Rule 1260-02.12, highlighting 5B, provision regarding offer, guarantee, and warranty, 2B, requiring firm name and telephone number on all advertising, and 4A, requiring firm name and phone number on each page of website, plus attendance by respondent at one entire regularly scheduled meeting of the Commission within 180 days of respondent's execution of the consent order.
Mr. Chairman,
Yes, Mr. McMullen.
motion to propose consent order for $1,000 for the cited statute and rule.
Second. And does that include attendance?
Yes, and all of the other particulars that are mentioned in the recommendation.
All right, so the motion on the floor is to adopt council's recommendation with the exception of the amount of civil penalty, and that's to increase to $1,000. That's been properly seconded. Is there discussion on the motion? Let's vote. Those in favor of the motion vote aye. Aye. Those opposed, no. That motion passes unanimously. Number 5.
2014026-291. Complainant states that respondent, broker, resided in complainant's rental property. Complainant alleges that respondent drafted a fraudulent lease with option to purchase contract and pasted complainant's signature on the contract. Complainant states that respondent has been complainant's agent over the years selling and managing rental properties. Complainant states that while a tenant in complainant's property between November 2010 and May 2014, respondent made numerous attempts to buy the home but was unable to secure financing. Complainant further states that at one point, respondent attempted to credit the 6% commission to the sales price without involving respondent's firm. Complainant further states that respondent stated the home appraised for $220,000 without providing a copy of the appraisal and told complainant that the home would not sell for more than the appraised value. Complainant alleges that while residing in the home, respondent refused complainant access to the home to show the home to a potential buyer. Complainant provided respondent with a 30-day notice to vacate and states that respondent's attorney responded to complainant, noting a lease with option to purchase contract that complainant had never seen or signed. Complainant alleges that the signature block was copied from the original lease onto the lease with option to purchase and states that the font and size are different. Complainant further states that respondent left considerable damage to the home and complainant sent a letter regarding damages, needed repairs, and requesting reimbursement. Complainant provided a copy of a general sessions judgment which was awarded to complainant in the amount of $12,770.95 plus costs against respondent for legal fees incurred while enforcing the lease, May rent, and costs incurred to repair the damage to the property during tenancy. Respondent sent a response to an attorney stating that not all of complainant's allegations are accurate or relevant and there are no specific allegations of a violation with TREC's rules and statutes. Respondent states that respondent managed a number of complainant's properties and approached complainant about personally renting the subject property in October or November 2010. Respondent states that respondent's tenancy occurred without incident and respondent continued to assist complainant with managing other rental properties without compensation. Respondent alleges that complainant was unable to refinance the home, so respondent approached complainant about purchasing the home. Legal counsel notes that there were no disclosures of agency status or regarding respondent's personal interest. Respondent attached a copy of a purchase and sale agreement for the subject property. Respondent states that pursuant to the purchase and sale agreement, an inspector found a 3-foot layer of water and mold beneath the house, and respondent alleges that complainant refused to repair the problem. Respondent states that respondent was unable to obtain financing for the home because of this problem, and complainant placed the home on the market while respondent continued to reside under the lease terms. Respondent states that complainant advised respondent that complainant would like to show the property potential buyers, but delivered a notice to vacate on April 1st. Respondent states that respondent's attorney contacted complainant in an effort to arrange an inspection and protect respondent's rights and provided a copy of the lease agreement. Respondent states that complainant alleges that the lease reference was not the lease complainant recalled executing, and complainant's attorney provided a copy of an alternative lease. Respondent acknowledges vacating in May 2014. Respondent states that respondent regrets the way the situation unfolded, but it is not a representation of respondent's conduct as a realtor. Respondent further states that respondent is relieved to know that nobody was injured or suffered serious harm, and the situation resolved favorably for complainant, who ultimately sold the home for an amount exceeding the appraisal. Complainant submitted additional information stating that respondent failed to address the complaint regarding respondent's alleged fraudulent lease. Complainant further states that complainant has been harmed by the situation due to legal fees incurred, and states that complainant is not able to collect the judgment because respondent has filed bankruptcy. Complainant further states that respondent was also a defendant in another general sessions court case in which the judge ruled against respondent in the capacity of a property manager for similar allegations. After attending that hearing, complainant recalled a conversation with respondent in 2012 when complainant noticed rent deposits for 3 months were missing from complainant's account. Complainant states that respondent said that one of the tenants had lost a job and respondent had agreed rent could be made up later. Complainant states that the money was later put into the account, but after the 2015 general sessions case, respondent checked with the tenant, who stated that there was no job loss, that they had never missed a rent payment, and that rent checks were made payable to respondent personally at respondent's instruction. Complainant states that complainant caught respondent attempting to steal rent money for that 3-month period. It appears to legal counsel that the signature block from the lease agreement was copied over to the lease with option to purchase, as the date immediately above the signature had an error and was written over, which does not seem to be a common mistake that would be identically repeated on 2 different documents. In addition, the signatures and dates are identical. It appears that complainant's allegations of respondent fraudulently altering a document are supported, and respondent did not deny the allegation in the response, which appears to be a violation of TCA section 6213-312B20. Additionally, it appears that a tenant was paying respondent directly for rental payments. Information from a former principal broker below further indicates that respondent was managing property outside of complainant's firm, and it appears to be a violation of 6213-312B11. Further, and of significant less concern to legal counsel, it appears that there was no written disclosure of agency status or a written personal interest disclosure to accompany the purchase and sale agreement executed between complainant and respondent in 2013. The recommendation is a consent order for revocation of respondent's license for violations of TCA sections 6213-312B11, which is accepting any valuable consideration for performance of acts specified within the chapter from anyone other than the principal broker. 14 and 20, any conduct that constitutes improper, fraudulent, or dishonest dealing. Also, 6213-403-7A, which involves disclosure of a personal interest in writing, and 6213-405A and B, which is written disclosure of agency status.
Motion to approve council's recommendation.
Second.
Okay, we have a motion to approve council's recommendation, which, if accepted by the licensee when it's presented, would cause that licensee's license to be revoked.
If it was accepted, nothing would happen. If they chose not to accept it, it would move forward to a formal.
Right. If they chose not to have their license automatically revoked or agreeably revoked, then we'd have a formal hearing on the case.
This is a broker.
This is a broker.
But not a principal broker.
Not a principal broker.
Okay.
No, sir.
All right, questions or comments, discussion? Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Now, just so I'm clear, so we have 2 more complaints related to this. And the 2 additional complaints have to do with the supervising broker or principal broker at 2 different periods of time. Is that what we have? Okay.
The first one, the one we're about to hear, was the person who was the principal broker at the time of the general sessions judgment was apparently only principal broker for a very, very short period of time, the recent period of time. And then the other one appears to have been open later when it was realized that that person was a principal broker during a larger period of time of when the acts allegedly took place.
Okay, thank you. Number 6.
2014026-311. Track open to complaint against respondent broker for failure to supervise the previous respondent, who I'll hereafter call broker in the response. In case number 2014026-291 above, respondent was the broker's principal broker from on or about July 14th, 2014 through on or about October 13th, 2014. Respondent states that respondent was not principal broker of the firm during the time period in which is the subject of the complaint, stating respondent moved from out of state in July 2014. Respondent states respondent had no knowledge of the General Sessions proceedings with the broker and the previous complainant until receipt of a complaint letter from the local association of realtors. Respondent further states that the complaint allegations are regarding activity outside of the firm. Respondent further acknowledges that the previous complainant stated the broker's actions were not conducted in the role of a realtor, but as a tenant. Respondent states that the firm does not condone any of the actions that caused the lawsuit and complaints, but states that the firm had no knowledge of the matter. Respondent states that when inquired, the broker dismissed the matter as personal, and respondent released the broker on October 10th, 2014. Respondent further states that the broker's previous principal broker reached out to the previous complainant and was informed that the broker was operating a property management business outside of the firm. Respondent states that this additional information, which respondent received after broker releasing the broker, confirmed respondent's original decision that respondent had done the right thing. Respondent strongly encourages the commission to look into the broker's dealings outside of the firm. It does not appear to legal counsel that the events giving rise to the recommended disciplinary action against the broker above took place during the time period that the respondent was the broker's principal broker. Additionally, it's legal counsel's opinion that there was not a failure to supervise by this respondent, and therefore the recommendation is to dismiss.
Move to dismiss.
Second.
Motion by Commissioner Franks, seconded by Commissioner DeChara, that this complaint be dismissed. Is there discussion? All right, let's vote. Those in favor of that motion, vote aye. Aye. Those opposed, no. The motion passes unanimously. Number 7.
2014027-271. Track open to complaint against respondent, principal broker, for failure to supervise the previous respondent broker, which was back in complaint 2014026-291 above, who hereafter will be called broker. Respondent supervised the broker from on or about September 16, 2008 through on or about September 7, 2013, and again from on or about June 16, 2014 through on or about July 14, 2014. Respondent states that respondent was not aware of any of the subject events between the broker and the previous complainant, including the General Sessions lawsuit. Respondent states that the firm is not a named party in the lawsuit. Respondent states that the broker's failure to share this information with respondent is against company policy, and respondent attached a copy of the policy documents with the broker's signature. Respondent studied the documents received by the local association of realtors on October 8th and discussed the matter with the broker on October 9th. Respondent states that the firm released the broker on October 10th and included a copy of the Trek 1 form. Respondent states that the only information that the firm has on the subject property is that it was the broker's home address on file. Respondent states that respondent contacted previous complainant to discuss the matter, and complainant confirmed that there was never any attempt to contact respondent or the successor principal broker, who was the respondent in case number 2014026-311 that you just heard, because the broker's business was conducted outside of the firm. Respondent states that the broker went out of the way to hide this information because the broker was aware it was illegal. Respondent states that the broker was fully aware that all original contracts, lease purchase agreements, and rental agreements were to be turned into the office, but the broker never provided any documents regarding the subject address. Respondent further states that none of the documents have the firm referenced in them. Respondent states that the firm offers excellent supervision of their agents by providing policy and procedures manual, ongoing training, and full-time broker accessibility. Respondent feels it was impossible to supervise the broker in this particular case because the actions were outside of the office and deliberately withheld from the office. Among documentation submitted, respondent provided an email from previous complainant stating that the broker manages 3 properties for complainant outside of the firm to offset the discounted rent of the subject property between 2011 through April 2014. Previous complainant states that the broker accepted rent checks at a P.O. box, sent tenant letters, deposited checks into the owner's account, fielded calls regarding repairs, hired repairmen, found tenants, and prepared leases. It does not appear to legal counsel, based on the current information within the file, that respondent had knowledge of the broker's activities. It seems likely that the broker took all possible steps to conceal the wrongful activities. Therefore, in legal counsel's opinion, there does not appear to be evidence of a failure to supervise by this respondent, and therefore the recommendation is to dismiss.
Move to dismiss.
Second.
Motion was made by Commissioner Franks, seconded by Commissioner DeChara, that this complaint be dismissed per council's recommendation. Is there discussion on the motion? Commissioner Bloom.
Yes. In the last paragraph, it says, among documentation submitted, respondent provided an email from previous complainant stating the broker manages 3 rental properties for complainant outside the firm. So the broker's testimony that he did not know anything about it, he's saying he did.
The email was sent in October when this all came to light and this person was broker released.
Okay, so am I correct that this person was with this broker September 2008 to November 2013 and June 2014 through July 2014, at which time these events took place?
According to the complainant, it says that the broker managed the property from 2011 through April 2014. So that would cover part of the first period of it, not that last month, though.
But the broker that is now saying, or you're saying or suggesting we should dismiss him, he did have this gentleman's license during that period of time.
Did, but what I'm saying is that the email that was provided by this person was from the complainant, was dated October 2014, when the local association contacted these people, and this principal broker, first that this person claims they heard of it, reached out to the complainant in October after moving on, but to research the allegations within the information received from the association, and that's when they discovered it.
Which one of these brokers was he working for when he's doing these things?
This one.
This one. Then this one is guilty of not supervising.
Well, you all can decide that. I don't see evidence of that is what my recommendation included.
I mean, you
so.
can turn your back at any time and say, I didn't see any evidence of that.
I also think it's possible for someone to conceal something, but that's up for you all to determine.
Agree, but the law is you're still responsible. I mean, or we could,
you up.
or we could.
I think that this person did exercise reasonable. I mean, I don't know that you can. I mean, under these circumstances, I don't see that. It could be there, but I did not have it.
I think we should always excuse somebody by saying he hid this from me. It's on my watch.
I got it. So
understand.
just so we keep track of where we are, we have a motion to dismiss. You have the floor, Mr. Bloom, if you'd like to offer a substitute motion.
Well,
we
I
have to
have a
vote on it.
question.
No, a substitute will take.
Oh, well, yes, I'd like to offer a substitute.
Can I ask a question first?
Sure.
Because Julie, even though you felt like there was no evidence that he failed to supervise, and he released the guy once it was brought to his attention, he then did turn around and hire him back.
No. This person just found out about it in October 2014, right around the time this complaint was filed with us. This person was broker released at that time and is not with this firm anymore.
Okay, so when he released him in November of 2013, he did not know it at that time.
That's when it all came to light, allegedly, according to.
Okay.
And when they were notified, this person was, well, actually, I believe the person was released when they were first. The timeline, I believe, was that they received information from the local association, and I do not have a copy of that complaint. They talked to the broker, and the broker dismissed it as a personal matter. The broker
When was that?
October of 2014. This person was actually no longer the principal broker of record, I don't believe, at that time.
Okay, so when he released him in November of 2013,
October 2014.
no, he left this broker and then went back to him. So when he left
Brokers
him
were
in
flip-flopping.
but when he left in 2013, he didn't know anything about it. When that hadn't come to light at that point.
It's and this is confusing to me too. The broker, the not principal broker, the first person we heard from, was at the same firm, I believe, the whole time.
Okay.
There was a change up of principal brokers in the meantime. There was no leaving the firm or coming back. This person had been with the firm. The principal brokers changed out. And I'm sorry, that probably wasn't totally clear. This person was principal broker for a while. I believe somebody else was principal broker for a while. The one we just heard from was principal broker for a short period of time after this, and that's what had switched over.
I got you.
I apologize. That probably was not clear with it being anonymous.
All right, Commissioner Bloom, you've got the floor.
Yes, I'd like to recommend a consent order for $1,000 and attend one of our our meetings in the next 180 days.
All right, Commissioner Bloom has offered a substitute motion that this particular broker be offered a consent agreement with a civil penalty of $1,000 and a required attendance at one of our meetings within the next 180 days.
For failure to supervise.
For failure to supervise. Is there a second to that motion?
Second.
All right, that motion now is properly on the floor, and the motion we're considering. Is there discussion about that motion? Commissioner Bloom's motion. Are you ready to vote? Let's do it. Those in favor of the motion vote aye.
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 Aye. Those opposed?
No.
Chair rules motion passes on a 3-2 vote. Number 8.
2014028-611. Complainants purchased a timeshare from respondent, which is a timeshare registration, in July 2013. Complainants state that they made the purchase because of verbal representations that were made, which complainants state turned out to be untrue. Complainants state that they were told that it would be a great investment, that complainants could make money, that values would double or triple upon completion, that getaway vacations would be available to complainants at low prices, and that respondent would buy the timeshare back. Complainants state that they would not have purchased the timeshare if they had known the truth, and respondent has been unwilling to resolve the misrepresentation issues.
Mr. Chairman, move to dismiss.
Second.
We have a motion to dismiss by Commissioner McMullen, seconded by Commissioner Franks. Is there discussion on the motion? Those in favor of the motion vote aye. Aye. Those opposed, no. The motion passes unanimously. Mr. Char, would you mind telling the audience what timeshares and this commission have in common?
Well,
Not much.
not much. We don't get along with timeshares because they have everything documented. Their I's are dotted, their T's are crossed, and when you go back and pull their paperwork, everything tends to be in order, and it becomes a he said, she said kind of thing, and so there's not really a whole lot we can do about it because their documentation is in order.
For the record, it was council's recommendation to dismiss that particular complaint. Number 9.
2014028-621. Complainants state that a representative of respondent timeshare registration made misrepresentations.
Second.
There's a motion by Commissioner McMullen, seconded by Commissioner Franks, that this particular timeshare complaint be dismissed, which is the recommendation of council. Is there discussion on the motion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 10.
2014028-651. Complainant entered into a sales contract to purchase a property owned by respondent affiliate broker's spouse, who is an owner and builder. Complainant alleges that the title company confirmed that there was a complaint against the property and the title could not be released. Complainant believes that it's unlikely that respondent did not know about this when listing the property. Respondent submitted a response stating that both respondent and respondent's spouse are agents, and respondent's spouse is the president of the corporation, which was the seller of the property. Complainant was represented by another agent in the transaction. Respondent states that the home was not on the market when complainant's offer was received, but complainant's agent contacted respondent to see if there were any properties available in the complex. Respondent states that the original offer was received on October 20th, 2014 and bound on October 23rd, 2014. Respondent states on October 30th, the day before closing, the title company contacted respondent regarding the chain of title, and the parties agreed to extend the closing to November 7th, 2014 to allow the title company to research the title in more detail. Respondent states that in good faith, the seller offered a different property in the same complex with the same floor plan and wrote an amendment to the contract on November 3rd, 2014, which included an $8,000 non-refundable change order to be applied to the closing statement. Respondent states that the complainant did not agree to the amendment and correspondence and or counteroffers ensued between the parties for alternative options. Respondent further states that complainant was given a last chance offer on November 6, 2012, but complainant rejected that afternoon. Respondent submitted a statement from complainant's agent who stated that the original home could not close due to title insurance, and complainant attempted to purchase a different property, but seller and complainant could not agree upon the terms. Respondent included a timeline of events in the transaction file. The information within the file does not appear to evidence a violation by respondent, and therefore the recommendation is to dismiss.
Motion to dismiss. Second.
Motion by Commissioner Chara, seconded by Commissioner Franks, that this complaint be dismissed per council's recommendation. Discussion. Let's vote. Those in favor of the motion say aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 11. sorry.
Okay, 11-2014-028-661. Trek opened a complaint against respondent principal broker for failure to supervise the previous respondent affiliate broker in complaint 2014-028-651 above, hereinafter affiliate broker. Respondent states that the events, timelines, contracts, and correspondence seem to show that there was no intent to harm, and there do not appear to be any violations of the law or ethical violations during the transaction. As principal broker, respondent states that respondent reviewed the supporting documentation and can find no wrongdoing. The recommendation is to dismiss.
So moved.
Second.
Motion by Commissioner DeChara, second by Commissioner McMullen, that this complaint be dismissed. Discussion. All in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Let's take one more and then take a break.
2014028-691. Complainant states the complainant lived with respondent, principal broker, and they built and bought a home together. Complainant alleges that upon separation, respondent attempted to have complainant quitclaim deed the home over to respondent. Complainant states that respondent filed an order of protection against complainant, and complainant was kicked out of the home. Complainant further alleges that respondent told complainant about a transaction in which respondent did not think the property would close because the buyers were not aware they did not have rights to use the road because of a cemetery. Complainant alleges that respondent did not notify the parties involved and the sale closed. Complainant further alleges that respondent gives out lockbox codes to friends to go into people's homes without the listing agent or homeowner's permission. Complainant also alleges that respondent stole sign holders and an information box from another agent. Complainant also alleges that respondent allows friends to hunt and fish on a listed property that has a lockbox on the gate without the owner's permission, and alleges that one person started a fire on the property and a boat was stolen off the property. Complainant further alleges that respondent did not relay an interested buyer to a client seller because the seller was about to foreclose on the property, and instead respondent contacted the banker and received a cash commission for referring the interested buyer. Complainant further states that respondent has received cash for real estate transactions. Respondent apologized that Trek has been involved with this issue, which arose out of domestic issues, and complainant's promise to ruin respondent. Respondent states that respondent offered $50,000 to complainant for their joint property when they separated, and further states that the order of protection was taken out due to complainant's threats and behavior. Respondent states that respondent has allowed complainant to live in their joint property, but the power has been cut off and complainant took all of their joint belongings. Respondent states that the property near the cemetery has a recorded right-of-way that was verified by the title company at closing. Respondent denies giving out lockbox information to anybody except other agents. Respondent denies stealing an information box and sign frame and states that the other agent verified that respondent bought the items. Regarding the property that had a fire, respondent states that it was a ground fire and the individuals that were there had done business with the owner and were invited by the owner. Respondent states that respondent does not know who stole the boat and states that the owners are not concerned because there was no value to it. Respondent states that the other people given access to this property were landscapers and the owners were aware of them. Respondent further states that the kids in the area know about the lake on the property and is used without permission as there are multiple ways to get on the property. Respondent denies being paid outside of closing and denies telling somebody to wait for a bankruptcy sale to purchase a property. Respondent states that complainant has attempted to ruin respondent's reputation by contacting respondent's business contacts, alleging similar things and encouraging them to file complaints with Trek. Respondent states that complainant has also contacted association boards and tampered with respondent's business Facebook page. Respondent further states that complainant had listed their joint home for sale, but respondent has no signed listing agreement. The recommendation is to dismiss.
So move.
Second.
Motion by Commissioner McMullen, seconded by Commissioner Franks, that this complaint be dismissed per council's recommendation.
Julie, does there appear to be anything to support all the allegations that the complainant made, or is it just?
I don't know how some of those things could ever be proven without knowing the people that were involved or having the actual alleged victims come forward. It appears to be essentially he said, she said, and there's definite evidence on both sides that this is a very contentious domestic issue. So while I'm not saying it's impossible, I don't see how, if all of these alleged terrible things occurred, that there's not been one other complaint against this person regarding any of this, and I don't see how I could chase all of this down.
Because, if that respondent was doing any of those things, it would be very disturbing, but.
Right, and I mean, if we received, for some reason, some kind of additional information that's, outside of this that were to substantiate any of this, then it might be something worth looking into. But it was all a narrative of allegations, and then likewise a response.
So we, just again for the audience and my sake, we don't know if there was a male and a female, who the complainant was, male or female, or whether they were both the same sex or anything, do we? You can't tell us, but I mean,
I
that's how
could
good
tell
a
you
job.
that probably. I
Doesn't
try
matter.
not to, but
Well, you
I,
gotta-
yeah.
I know it doesn't matter, but I'm just saying how good a job council does at disguising the scenario. So we just have to make a decision on testimony of some sort or another that was provided. All right. Any other discussion or comments? Let's vote. If you're in favor of the motion to dismiss, please vote aye.
Aye.
Opposed, no. Motion passes unanimously. We're going to take a 10-minute break. For those of you guys keeping track, we just finished complaint number 12. We have 31 total, so some will move quickly and some might take a little time, but compared to 50 or 60 we've had in the past, it's a piece of cake. Back in 10 minutes, please.
My son's going to be in trouble all the time. Here we go.
Ms. Crop, are you ready?
Yes, I'm
Got-
ready.
Number 13, please.
Okay. 2014028-701. Complainants state that respondent, affiliate broker, was complainant's agent in the attempted purchase of property. Complainants state that respondent showed the property to complainant several times, but complainants were unsure of where the property lines were. Complainants state they had a map that respondent and one of the complainants walked the property, and a surveyor's marker was found and used to establish where one corner of the property was located. Complainants entered into a contract to purchase the property's 3 parcels. On the day of closing, complainants state that they met respondent's principal broker, the listing broker on the property, who went over the property complainants were purchasing. Complainants state that his description was very different than what complainants were shown. Complainants decided not to go through with the purchase. Complainants believe that they should have received a return of their earnest money and payment of other expenses. Respondent states that the subject property was listed by respondent's principal broker, and the principal broker had provided respondent with a plat that was clearly marked that the drawings on the plat were not to scale. Respondent states that the owner had hired a surveyor to mark the property lines, but those were not visible from the house. Respondent states that when respondent met complainants the second time, respondent brought the plat map provided by the seller to show to potential buyers, as well as the printed plat map from the courthouse records. Respondent states that respondent explained to complainants that the courthouse plat maps have no guarantees as to accuracy and are often inaccurate. Respondent states that one of the complainants wanted to walk the property to look for boundary markers, so they did, but were only able to find one marker that could have been the boundary marker for any one of the 3 properties. Respondent states that one of the complainants made an assumption based on the map provided, and respondent states that neither respondent nor respondent's principal broker would make any assumptions or guarantees regarding the boundaries. Complainants made an offer, and respondent states that respondent told complainants that, as outlined in the purchase and sale agreement, complainants had the right to obtain a survey, and a survey is the best means for identifying boundary lines, encroachments, and/or easements. Respondent states that complainants also signed a disclaimer notice advising buyers to get a survey. Respondent states that the issue was discussed at length with complainants, who stated they would discuss a survey amongst themselves. On closing day, respondent states that the buyers and respondent's principal broker arrived about 10 minutes before respondent and began a serious discussion about the boundary lines. Respondent states complainants were questioning the principal broker about a particular line, and the principal broker stated that he could not commit to identifying the boundaries, which upset one of the complainants. Respondent states that one of the complainants stated that if he could not be assured of the boundary, then he would not purchase the property. Because neither respondent nor the principal broker could guarantee the boundary placements, complainants left the closing and did not complete the purchase. Respondent states that respondent enjoyed working with complainants and wishes the transaction had ended differently. There does not appear to be a violation by respondent, and therefore the recommendation is to dismiss.
Move to dismiss.
Second.
We have a motion by Commissioner Frank, seconded by Commissioner Chara, that this complaint be dismissed per council's recommendation. Is there discussion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 14.
2014028-711. A complaint was opened against respondent, principal broker, on a potential failure to supervise issue regarding the previous respondent affiliate broker in complaint 2014028-701 above, hereinafter affiliate broker. Respondent states that respondent is very familiar with the transaction because respondent was the listing agent on the property. Respondent states that the affiliate broker submitted an offer and the property went under contract. Respondent met complainants.
I'd like to move that we accept council's decision to dismiss.
Second.
Thank you, Commissioner Bloom, seconded by Commissioner McMullen. The motion is to dismiss. Is there discussion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. The rationale, for those of you not following closely, is that in the previous complaint, the affiliate was found, or the complaint was dismissed, so the likelihood of failure to supervise on the part of the principal broker is slim and none. And that's how the commission has voted. Number 15.
201402871, a complaint was opened against respondent broker based on the allegations contained within complaint 201402870 above. This respondent was never referenced in the narrative of complainants regarding the subject property, and complainants never described any alleged wrongdoing on the part of this respondent within the complaint. Respondent states that in September or October 2013, respondent was contacted by the complainant's daughter, which was an acquaintance of respondent, who informed respondent that complainants wanted to look at property listed by the firm. Respondent was out of town and had the affiliate broker in complaint 201402870 above, hereinafter affiliate broker, contact complainants to assist them. Respondent states from that point on, respondent was not involved in the transaction. Respondent states that the affiliate broker made several trips to the property with complainants, wrote the offer, and took the earnest money check to the firm. Respondent states that when the offer was written, the affiliate broker typed respondent's name as well as the affiliate broker's name at the bottom of the contract because the affiliate broker was at the time unsure whether respondent would be assisting when respondent returned to town. Respondent states that respondent never got involved in the transaction. Respondent states that complainants refused to close. Respondent states that complainants were given several opportunities to have a survey done of the property as shown on the F14 disclaimer notice, as evidenced by a document from the credit union wherein complainants signed that they waived a survey at the time they made their loan application.
Move to dismiss.
Second.
Commissioner Bloom has heard enough, and he moves to dismiss.
This was one of the ones that you all had in the draft, and he's, I'm sure, read this. This was sent to you all ahead of time for pre-review.
And the next one, too, I anticipate a quick motion on that.
Okay. Yeah, I know you all have individually read these, and so if you don't have questions.
So Commissioner Frank seconded Commissioner Bloom's motion to accept council's recommendation to dismiss. Is there discussion on the motion? Let's vote. Those in favor of the motion vote aye. Those opposed, no. That motion passes unanimously. Number 16.
201402871. This complaint against
Dismiss.
I am really good at this. We have a motion by Commissioner McMullen, seconded by Commissioner DeChara, that complaint number 16 be dismissed per council's recommendation. Is there discussion on the motion? Let's vote. Those in favor vote aye. Those opposed, no. The motion passes unanimously. Number 17.
This is another, 201402961. This complaint was opened against respondent principal broker on a potential failure to supervise issue regarding the respondent broker and
Move to
complaint.
dismiss.
Second.
Motion by Commissioner McMullen, seconded by Commissioner DeChara, that this particular complaint be dismissed. Is there discussion? Are we done with this story?
Yes, the one before this was actually opened in error, which is the short of it for those that didn't hear the summary. The one before this was an error. This was a failure to supervise. Again, no wrongdoing, no documentation indicating wrongdoing.
Let's vote. Those in favor of the motion to dismiss vote aye. Aye. Those opposed, no. The motion passes unanimously. Number 18.
201402871. Complainant purchased respondent, principal broker, and spouse's residence in 2005. Complainant states that respondent had done extensive remodeling, including a large A-frame addition. In 2014, complainant listed the home for sale, and the property was under contract to sell, but the bank rescinded the buyer's loan because it was discovered that a large portion of the septic tank was under the concrete floor of the extension, making it impossible to remove the top of the tank. Complainant further states that respondent installed an electric underfloor heating system, which could be dangerous due to buildup of methane gas from the septic tank. Complainant further states that the septic permit is for 2 bedrooms, but the property has 3 bedrooms. Complainant attached documentation including septic permits from 1985 and 1993. Respondent states because this closed in 2005, respondent does not have a copy of the transaction documents other than what is available in the MLS. Respondent states that everything relating to the construction and exterior of the home was carried out by a licensed contractor who arranged architectural drawings to be completed and submitted to the Architectural Control Committee. Respondent states that the addition was completed in full compliance of any codes that were in place at the time of the addition. Respondent further states that the home itself is on a concrete slab, but the addition was constructed with footings. Respondent states that respondent has no knowledge of any works being carried out in 1993, as the septic permit is unsigned by respondent's spouse. Respondent states that at the time complainant purchased the home from respondent in 2005, it was not required to apply for the septic permit when listing a property, and to the best of respondent's knowledge, the home was a 3-bedroom home. Respondent further states that complainant contacted respondent in March 2014 to sell the property, and respondent printed tax information and prepared a TAR form requesting septic information from the state. Respondent states that the information was not received and the listing was put on hold waiting to hear back from complainant. Respondent states that complainant contacted respondent regarding the issue, but under the advisement of an attorney, respondent did not return complainant's call. Respondent denies allegations of misconduct, false documentation, or wrongdoing. It does not appear that respondent's spouse signed the 1993 permit, and Rule 1260-02-.37 regarding septic system inspection letters was not effective until 2000. 2008. It does not appear to legal counsel that there is proof of respondent having knowledge and failing to disclose adverse facts during the 2005 sale. Therefore, the recommendation is to dismiss.
Move to dismiss.
Second.
Motion by Commissioner Franks, seconded by Commissioner DeChar, that this complaint be dismissed per council's recommendation. If you're in favor of the motion, please vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 19.
20140287771. A complaint was filed by sellers against respondent, buyer's agent, also an affiliate broker, regarding the potential sale of a home that was set to close on October 30th, 2014. Complainants allege that complainants were told that the buyers were pre-approved for a $175,000 loan. Complainants allege that the potential lender withdrew the pre-approval, that alternate lending was made available to the buyer, but that buyer did not pursue the alternate lending. Complainants state that complainant's agent requested a copy of the denial letter several times from respondent and principal broker, but it was not provided. Complainants state that one of the complainants went to respondent's office on October 15th requesting a copy of the withdrawal for approval and alleges that the principal broker advised that the principal broker did not have it, but that the buyers were approved for $147,000. Complainant alleges that the principal broker called the lending institution, who stated that the lender who signed the letter was on vacation. They could not provide a copy until the lender returned. Respondent sent a response addressing buyer's obligations regarding the loan as stated in the purchase and sale agreement and seller's remedies if buyer did not perform. Respondent states that sellers at no time presented any written demand for compliance and failed to exercise the remedies provided in the contract. Respondent further states that the contract was contingent on buyer's ability to obtain a loan in the principal amount up to 90% of the purchase price. Respondent states that the buyers were provided with a letter from the lender dated October 20th, 2014 that stated while they were conditionally approved for $175,000, further underwriting requirements made the maximum loan amount $148,100. Respondent further states that respondent initially offered to send complainant's agent a pre-approval letter, but the agent declined. Respondent further states that there is no evidence of complainant's allegation that buyers were offered alternative financing but did not pursue it. It is respondent's opinion that complainants did not pursue remedies available to them in the binding contract, and buyers should obtain a full refund of the earnest money. Complainants submitted additional information stating that complainant's agent initially agreed that a pre-approval letter was not needed at that stage, but did not imply it was not expected at any point. Complainants state that complainant's agent's numerous requests for the same verifies that the pre-approval letter and or denial letter was requested. Complainants further state that complainant's agents gave respondent information regarding a different lender who was willing to work with buyers in lieu of their debt-to-income ratio. Complainants further state that the October 20th letter was not provided until October 29th, which was one day before closing was to occur, which kept complainant's house off the market. Office of Legal Counsel requested and reviewed the transaction documents. It appears that the offer was faxed with comments on the fact sheet dated September 18th, 2014 that states that the buyer is pre-approved through the bank. The contract was contingent upon buyer obtaining a loan for 90% of the $180,500 purchase price. The contract was bound on or about September 18th, 2014 for a closing date of October 30th, 2014. There's a personal interest disclosure stating that respondent's immediate family member is the prospective buyer. The earnest money in the amount of $1,000 is to be held at respondent's firm. There was no pre-approval letter provided with the documentation, but there's a letter from the lender dated October 20th stating that the buyer was conditionally approved for a $175,000 mortgage, but further underwriting stated only $148,100 would be approved. It appears that this letter was faxed to complainant's agent on October 28, 2014. It appears that approximately 2 weeks passed before the lender sent the denial letter to the buyers on October 20, 2014. Respondent then sent this letter to complainant's agent via fax on October 28, 2014, it appears. This is still 2 days prior to the scheduled closing, and it is legal counsel's opinion that this did not constitute wrongdoing, and the recommendation is to dismiss.
So moved. Second.
So we have a motion by Commissioner Franks, second by Commissioner DeChar. The council's or vice versa, excuse me. Commissioner Franks seconded, Commissioner DeChar made the motion. To dismiss per council's recommendation, is there discussion? Julie, was there any discussion about disposition of the earnest money?
The money was dispersed to the buyers ultimately. It was a couple months later, but as far as a violation of our earnest money rule, I did not see a written demand that would have made that disbursement at a later time untimely. But it was dispersed. It's not currently still being held.
Either party asked for the money?
No, I did not have that written request in the file. That didn't appear to be part of the allegations, and I did not have that written demand in there. And we asked for a full copy of the transaction file, and there was not anything in there of that.
Other questions or discussion? Motions to dismiss. Let's vote. Those in favor say aye.
Aye.
Those opposed, no. It passes unanimously. Number 20.
201402871. Track opened a complaint against respondent principal broker for failure to supervise the previous respondent affiliate broker in complaint
Move to
20.
dismiss. Second.
We have a motion by Commissioner Frank, seconded by Commissioner DeChara, that this complaint be dismissed per council's recommendation. Discussion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. 21.
20140280801. Complainant states that the subject property was listed on May 15, 2014 by respondent, affiliate broker. Complainant states the complainant contacted respondent on May 17, 2014 to see the property and was told there was a contract on the house and complainant could not see the house. Complainant states that respondent purchased the property and put it back on the market for a substantially higher price later in the year. Complainant states that another realtor advised complainant that respondent had an obligation to show the property to complainant as it could have been a backup offer. Complainant states the complainant followed up with the house when the house was still on the market a couple months later, and respondent advised that respondent was trying to get a new roof. Complainant states that if this was complainant's house and the realtor advised a listing at one price and then it was listed a few months later for a substantially larger amount, complainant would be very upset. Respondent states that the subject property was listed on May 14, 2014. The seller was the trustee of an estate, a bank, who respondent had been working with since March 2013. Respondent states that the home was in poor condition but had good bones, and respondent liked the location. Respondent states that respondent emailed an informal offer on May 14th, but before a reply was given, the first offer arrived on May 15th. Respondent then wrote the second offer on May 15th. A third and fourth offer arrived on May 15, 2014. Respondent states that all parties were aware that it was a multiple offer situation. On the morning of May 16th, the seller accepted respondent's offer. Respondent states that the complainant called respondent on May 17th, but it was not respondent's recollection that complainant could not see the house. Respondent states that respondent tells buyers if there's an accepted contract and allows them to make a decision as to whether or not they would like to see it. Most, respondent states, ask to be contacted if the contract does not work out. Respondent states that complainant emailed through a website on May 20th stating that complainant spoke with respondent on May 17th and respondent advised there was a contract with respondent buying the property, and if respondent changed respondent's mind and the house was going to be listed at the current price, please contact complainant. Respondent states that the home inspection noted termite infestation and a failing roof, so respondent requested termite treatment and a roof replacement by repair replacement amendment, which was agreed to by the seller. Ultimately, the seller's insurance would not pay for the roof, and the seller agreed to pay for it, but the process took a significant period of time, according to respondent. Respondent states that respondent put a significant amount of money into the home and sold the home a few months later for an increased price. Respondent denies misleading anyone. Respondent provided documentation, including but not limited to before and after photographs of the house, transaction documents from the initial listing, the initial offers, and respondent's purchase, as well as respondent's subsequent listing and sale of the subject property after purchase, along with many emails between respondent and the vice president of the bank, which served as the trustee of the estate, which was the first seller of the subject property. Complainant submitted an additional response reasserting that complainant was told that the property could not be shown. In legal counsel's opinion, the documentation in the file does not appear to evidence a violation by respondent, and therefore the recommendation is to dismiss.
Move to dismiss.
Motion by Commissioner Frank, seconded quietly by Commissioner McMullen, that this complaint be dismissed per council's recommendation. Is there discussion?
Julie, in this, the respondent was the listing agent. Yes. And he's also the one who got the house.
Yes.
In a multi-offer situation.
Yes.
That's bothersome to me.
Okay.
He opens all the other bids, and his just happens to outbid everybody else's.
If I'm missing something here, tell me. I saw personal interest disclosure signed with this person, and
typically, well, this may not be the case since it's a bank, but typically you cannot buy your own listings with these foreclosures.
It wasn't a foreclosure, though. It was an estate, and it was a bank that was doing it.
Well,
there may be
banks do
something I'm
that.
not aware of here, and I've got a lot of transaction documents. I'll be happy to look something up if there's something that you're wanting me to zero in on that I'm missing here. Like I said, I reviewed all the transaction documents, and it appeared that they were all in order to me. But I'd be happy to answer any
Was
questions.
there a multi-offer form submitted to the other agents?
I did not see it. Actually, at least one of the other offers were from fellow agents as well. But there were emails in there saying this is a multi-offer situation. But no, I did not see that the TAR form for the multi-offer situation.
Well, but
was
I mean,
filled
was
out.
it sent to the other agents? Was there an email sent to the other agents notifying them that it was a multi-offer?
I know that there was one for one of them, and there was a note on it that said that the person had submitted the offer after knowing there were already multiple offers in. So
States in here that all parties were aware is multiple offer situation.
that's what the person stated. The respondent stated that they were all aware of it. And I did see at least one email where the person said there are multiple offers. You should submit your best and highest offer. And that was to a licensee that was also buying the property for themselves.
I think it's more ethical,
itself.
maybe,
I mean, I'd be
than
happy.
a TREC item that needs disciplinary action.
Was the bank the seller?
It was the bank as the trustee. I believe it said trustee of an estate,
And
but
the
it was a
listing-
vice president. It was an attorney for a
And the
bank.
listing
that was
agent sold it, bought it.
Correct.
Well, unless there's collusion between those two, they're the ones that would have been arguing about what we're talking about. The bank.
Again, yeah, no, and the bank submitted a statement saying that they were aware that this person had then listed the house for a higher price a couple months later, and that they understand that significant work had been done. Again,
That doesn't bother me. I mean,
No,
that's just a typical house flip.
I mean, again, there seemed to be communication with the bank, and like I said, it was a vice president of this bank that was, it said, I think it said JD at the end of the name. So, I mean, it appeared to be a reasonably sophisticated seller acting on behalf of the bank. But I'd be happy to pull up, if there's this was a kind of unique situation. I looked at the documentation. It all looked like it was there. But, I mean, I don't know if.
It happens.
What's your pleasure, Mr. Chara?
Well, I'm like Marcia. I certainly think there's an ethics complaint there, but vote on it. Vote on your motion.
Okay, I just wanted to give you a chance to, if you had a substitute motion, let's just see how you vote then on the motion, which is on the floor. Is there other discussion? Let's vote. Those in favor of the motion to dismiss, vote aye.
Aye.
Those opposed, no.
No.
The chair rules that the vote was 4 aye and 1 no. Mr. Char was the no vote, surprisingly. Thank you, Julie. Number 22.
20140289001. A complaint was opened against respondent principal broker on a potential failure to supervise issue regarding the previous respondent affiliate broker in complaint 20140288801 above, hereinafter affiliate broker. Respondent submitted a response stating that the affiliate broker came to respondent's firm as an experienced realtor in 2009. Since that time, respondent states that the affiliate broker's dealings with consumers and other agents has been beyond reproach, and respondent does not think that the affiliate broker acted any differently in this transaction. Respondent states that respondent viewed the transaction with complainant, and respondent is comfortable with the fact that the affiliate broker made the property available to complainant, and respondent supports affiliate broker's point-by-point response. Respondent states that respondent is a full-time broker who is available to respondent's licensees at all times. The recommendation is to dismiss.
Move to dismiss.
Second.
I have a motion by Commissioner Franks, seconded by Commissioner McMullen. Commissioner Chara couldn't second it because she voted against the last one, so it'd be hypocritical for her to make a motion on this one. Is there discussion on the motion? All right, let's vote. If you're in favor of this motion being dismissed, please vote aye.
Aye.
If you're opposed, vote no.
No.
Thank you. The motion passes on a 4-1 vote. Mr. Chara is a no vote. Number 23.
20140288981. Complainant searched Zillow.com for a home in a specified area of the state. Complainant states that a home appeared which Zillow stated was in foreclosure, and Zillow said to contact a licensee's team for more information. The licensee is affiliated with respondent, principal broker's firm. Complainant contacted the licensee, who complainant states informed complainant that the home is in pre-foreclosure and is not on the market, but the licensee offered to help complainant find a home. Respondent believes that the listing is false in an attempt to solicit new leads illegally. Respondent states that complainant is upset that Zillow.com features pre-foreclosures and foreclosures that are not for sale as pre-market or potential
Move
listings.
to dismiss.
Second.
Motion by Commissioner Bloom, seconded by Commissioner Franks, to accept council's recommendation and dismiss. Mr. Bloom, I just noticed something in the tone of your voice on that motion that indicated to me that you don't really like Zillow as much as, say, some
No,
other.
we can't regulate them.
I understand. So it's nothing personal?
No.
Okay. All right, is there further discussion on the motion? The motion is to dismiss. Let's vote. If you're in favor, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. 24.
201402891. Complainant states that complainant called and submitted an online request to view a foreclosure property. Receiving no reply, complainant states that complainant emailed respondent principal broker listing agent a few days later. Complainant states that complainant received a phone call from respondent who stated that there was an offer on the house already. Complainant states that upon inquiry, respondent stated that the offer had not been accepted, and complainant expressed interest in making an offer. Complainant states that respondent stated that complainant had not seen the property yet, but respondent would verbally relay the offer to the bank. Complainant offered to sign paperwork and turn over earnest money, but complainant alleges that respondent said that was not necessary. On the following day, complainant states that complainant asked respondent to send paperwork so complainant could submit a written offer, but respondent replied stating it was too late because the bank had accepted the first offer. Complainant alleges that respondent delayed communication and did not act appropriately. Respondent submitted a response stating that the property address was not provided in the complaint. Respondent states that respondent does not have a website in which online requests can be submitted. Respondent notes that complainant states that complainant was out of town and had not viewed the property. Respondent states that the liability risk is too great for respondent to write a contract for a purchase with the buyer not having viewed and inspected the property. Respondent states that respondent represents several banks and market foreclosures and states that their addendums request the buyer to view and perform inspections on the properties because the banks are not liable for the condition of the property. Respondent further states that often when a bank is negotiating a contract on their online platform, it does not accept an additional offer until it completes negotiations with the first offer. Respondent further states that all offers have to be in writing with proof of purchase or a pre-approval letter from the lender. Respondent states that respondent can email an asset manager and advise that there may be an interested buyer that has inquired regarding the property and may use a backup offer if the first contract should fall through. The recommendation is to dismiss.
I have a little problem with this one too.
Okay.
It says that the complainant wanted to make an offer. He wouldn't submit the offer because the complainant hadn't seen the property. Now, I'm here to tell you, in this day and age, we sell properties all the time that people don't see. I think that agent, in this case, probably overstepped their bounds by not submitting that offer. But without knowing the details of it, it may be perfectly in line, but I think they had instructions from a buyer to submit an offer and refused to do so the way this is worded.
This was all the information I did have. There was not any supporting documentation that was submitted from the complainant and really, or the respondent, because the respondent doesn't even seem to be completely positive of which address it was. So my summary is pretty inclusive of all the information I have here. If there's something else that you'd like to have, something that's troubling you, you'd like to see more of, I could get that. Or if you just, as it is, have a problem with it, that's fine too. But I believe this is pretty much all of the information I have in this file.
And these are banks and market foreclosures where they may have been required, it says here that they're required to view them and perform inspections.
It was a foreclosure property. That appeared to be
She
stated
doesn't
by
have
both
any
sides.
proof of that either.
Well, that was said by both sides. I think the complainant said there was a foreclosure property listed that we were interested in.
No, I'm saying we don't have any proof of the addendum saying
No, I
that
don't
you
have copies
to-
of those. No, I don't. I only have what was alleged on both sides. That's all I do have. And
the foreclosure properties I have listed that I submit offers online, I have to have very minimal information. Name, email address, how much they want to offer. And that's
Just depends
basic.
on the bank, and in Tennessee,
that's what I'm
we got
saying.
thousands of banks, thousands of little banks that have their own rules.
That's what I'm saying. So you don't know whether that addendum is.
Did the respondent fail to obey a lawful instruction of the client?
That's kind of my point.
I don't think they were clients here. It would be all parties to the transaction type deal because there was no agency relationship here. These are people that allegedly
But they
called.
tried to establish a relationship.
I don't know. I think we would need to have an agency agreement to imply an agency relationship, but there is duties to all parties in the transaction. If there's an issue there, I think that would be something that could be appropriate here, but I think to imply that they were clients without
Well,
any kind of.
I'm not necessarily saying that they're clients. I'm saying they told him to submit an offer, and he refused to submit that offer.
Well, in that case, I would think the person complaining would be the bank.
Bank
And that's who
doesn't
the
know
client,
it.
the bank is the client. If I'm an owner of a property and my agent doesn't submit offers, I might have a complaint.
They don't have a clue. When it's
Well,
foreclosure, they don't have a clue whether
I
offers are
agree.
submitted or not.
From the reading of the response, and I'm not trying to put words in this person's mouth, but because there was not a property address or anything, the way the response was written was this agent was not entirely sure which property it was. It was saying often banks do this, often banks do that. I don't even know that this particular principal broker was exactly sure of which property this person had called about because that information was not provided. And so I don't know if that makes a difference or not, but from my reading of it, I don't think that this person was trying to give blanket excuses for this particular set of circumstances. I'm not sure. It was opened with, I don't even have a property address on this. Here's the general way things go. Like I said, I can try to get more information, but that's my inclination from reading the response was this person wasn't exactly sure.
Did the complainant provide an address?
They did not.
That's not much. I move to dismiss.
Second.
I have a second by Commissioner Bloom after a motion by Commissioner Franks to dismiss was offered. Is there a discussion on the motion? Ms. McMullen, you okay? Yes, sir. Let's vote then. All in favor of the motion, vote aye.
Aye.
Those opposed, no.
No.
Vote passes on a 4-1 vote. Mr. Chara votes no. Number 25.
201402911. Complainants were existing timeshare owners who purchased timeshare points during a
Move to
stay with.
dismiss.
Second.
Motion by Commissioner Franks, seconded by Commissioner DeChar to dismiss this timeshare complaint. Discussion. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. 26.
26 and 27 here together, 20140290021, 20140290022. A complaint was filed against respondents, unlicensed individuals, husband and wife, regarding potential unlicensed activity. On or about October 15, 2014, respondents advertised on a website that we specialize in helping good people into the home of their dreams through our lease option/rent-to-own program. The About Us section states that respondents are a husband and wife team of real estate investors who specialize in helping people buy homes even in difficult market conditions. The website further states we will work closely with you as a potential buyer, helping you find the right home, getting you accepted by the seller, and helping you qualify to buy the home after your lease period is over. Respondents state they've been real estate investors for years and just started investigating lease options in the last 18 months or so. Respondents state that they received contracts from a mentor who has done lease options for over 25 years, and they were reviewed by 2 real estate attorneys. Respondents state that they decided to pursue their real estate licenses long before the complaint had been received. Respondents state that they purchased a course and are working through it and have a broker they want to work with after they pass the test. Respondents state that they will not handle any more lease option transactions until fully licensed. Office of Legal Counsel performed additional research. It appears that the corporation was dissolved in August 2013 and changed to inactive revoked in January 2015. There was also an LLC registered with the same name and was inactive dissolved in August 2014. There were 10 properties listed on the website printout, none of which are owned by respondents nor sold since the advertised listing on respondents' website. Office of Legal Counsel reviewed the website again on March 26, 2015, and it appears that the same properties are still advertised, some of which are advertised as sold. It does not appear that either respondent has obtained licensure with TREC. The recommendation is for each respondent to consent order for $1,000 for unlicensed activity in violation of TCA sections 6213-103 and 6213-301. Said order to also include an order to cease and desist all unlicensed activity.
What's the maximum penalty?
1,000 each.
A thousand. Technically, your civil penalty rule has a maximum of 1,000 for violation of 103, which is regarding unlicensed activity. 301 also has a maximum range of $1,000. They're both statutes essentially saying the same thing, but they both have their own civil penalty ranges in your rule. Now, there are 10 properties that were advertised on the website.
It could be $2,000 per property.
I think that you could probably do that, and that's not even taking it day by day, and I don't know that we have proof of that here.
I make a motion that we assess for unlicensed activity $2,000 each, and that we also include an order to cease and desist all illegal unlicensed activity.
Second.
Okay, the motion on the floor kind of ratchets up what council recommended of $1,000 each. It's now $2,000 each and includes a cease and desist order.
Got it.
And for the-
And this is because there are too many people who work hard to keep their licenses current and do their education and get their E&Os. And then you've got people like this that come along that don't want to do any of that. And so we need to shut them down as much as we can.
Thank you, Ms. Franks. We could bump it even more if you wanted to.
I know, y'all could.
And if it comes
bump
down to
if
a
you want
hearing, you all certainly could.
When you say 2,000 each, do you mean 2,000 times 10 properties? Is that what you're saying?
What do y'all want to do? We're discussing.
Is that
I thought you meant 2,000 total on each
I
consent
said-
order,
I
but
said
I could have
2,000
misheard
each.
you. I'm sorry.
Because a lot of these houses they're selling, they may make $2,000 a commission off of it. So it behooves them to keep doing it. And who enforces the cease and desist? A
think we-
DA that might have somebody that have time to do that? I don't think so.
I think we ought
About-
to go to $20,000.
About 500 for each property for each participant. That's $5,000 each.
I think we ought to go to $2,000 per property, make it $20,000.
All right,
That might stop them.
it'd get my attention.
Well, that's the problem. If the fines or the penalties are not steep enough, it's like you
That's
said,
right.
we're making enough money, we'll just sell another
Then
property.
somebody amend it for
Well,
them.
we have had a lot of people that have corrected it after they've gotten it, and then our cease and desist in response to somebody's question, by putting that in there, if we then get, if these people sign it, agreeing to cease and desist, and then we get another complaint that they're still doing it, you all would have that in consideration, that they signed something agreeing to stop and then still continued to do it too, so that's.
ALJ thought it was pretty serious. They
That's
did
what- that's-
$290,000.
That's what I'm thinking. They got an offer to get out for 20,000 right now. They
Okay,
don't want to take that. Maybe they get hit for 200,000 when they go to the ALJ. I move to amend the motion and make it a $20,000 civil penalty consent order.
Per person.
Per person. That's fine. Sure.
Dang. So we're up to $40,000, as I understand the amended motion, plus a cease and desist letter. Is there discussion on the motion? Do we get a second to that, by the way?
Bam.
Was that a second?
My redneck's coming out. Yes, that was a second.
There's not a redneck in Franklin.
All right, so as I understand the motion right now, if it passes, each of these two individuals, if they agree to the consent order, will pay $20,000 and agree not to do any more of this. Are you ready to vote? I hope so. Let's do it. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
It does seem we get meaner as the day goes on.
No, we don't. I would disagree with that. I would like a beer more as the day goes on, but I don't. Number 28.
201429071. A complaint was filed against respondent unlicensed for potential unlicensed activity. Respondent is the contact person for a company who advertises on a website stating they are a multi-service company which buys, repairs, manages, and sells homes. The website states that they work with buyers who move into the property, then work to qualify and secure the loan. Respondent submitted a response stating that respondent falls under the exemption in TCA section 6213-104A1D, which states that the chapter does not apply to a person acting as a receiver, trustee in bankruptcy, administrator, executor, or guardian, trustee acting under a trust agreement, deed of trust, or will, or while acting under a court order or instrument. There is also another person who signed as manager stating that he falls under the exemption found at TCA section 6213-104A1E for resident managers. However, a complaint is not currently open on that individual. individual. Respondent signed the complaint as trustee. Respondent also included a copy of 2 warranty deeds, one of which grants respondent as trustee for one of the 6 properties advertised on the website. The warranty deed states that the property is being conveyed to a land trust, an executory trust, with respondent as trustee. Office of Legal Counsel researched the properties advertised. It appears that respondent shows up in the sale history as trustee for 2 of the properties, but does not even appear on the others. It appears to legal counsel that this use of a land or executory trust is not included within the exemption found at section 6213-104A1D cited above. The recommendation is a consent order for $2,000 for unlicensed activity in violation of TCA sections 6213-103 and 6213-301. Said order to also include an order to cease and desist all unlicensed activity.
Follow suit, 2,000 apiece.
There's only one.
Properties.
Oh, we went one person.
Yeah.
So 6 times 2 would be 12.
6 properties.
Is that right? There's 6
Yep,
properties?
one of 6
There were
properties.
6 on the property. Again, the person showed up as a trustee for 2 of them, but I don't believe this land trust or executory trust falls within. I mean, it's not a deed of trust, not a trustee acting under any kind of trust agreement. It's just setting this up to make it, what it looks like to me, make it look like it falls within one of our exemptions, and I don't think it works for any of
Little
them.
fraud going on maybe?
I think it's somebody trying to fall under one of our exemptions, which happens a lot, and it's not one of the things listed in that section.
Well, I personally think we need to follow suit, and what's good for one's good for the other. I'll make a motion, we offer a consent order for $12,000 for unlicensed activity in violation of TCA 6213-103 and 6213-301, and a order to cease and desist.
Second.
Okay, the motion on the floor, if approved, will offer this individual the chance to settle for $12,000 as long as they sign a letter or accept a letter agreeing to cease and desist. That's the motion on the floor. Is there discussion on the motion? I don't think there is. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. 29.
2014029-081. A complaint was filed alleging that respondent, unlicensed individual, is an unlicensed agent and company. Respondent's website was printed on October 14, 2014, in which approximately 10 properties were advertised for sale or lease purchase. The About Us section of the website states that the company prides itself in being a real estate investment company that provides creative win-win real estate solutions for home sellers, home buyers, and investors. It states that they buy and sell all types of real estate and work with buyers who want to secure a home and live in it now. There are applications and agreement forms that can be filled out on the website. Respondent is the contact person for the website. Respondent sent in a response stating that respondent is not in violation and falls under the exemption, but does not specify which exemption or go into further detail. Office of Legal Counsel performed additional research, and it does not appear that respondent's company is registered with the Secretary of State. Office of Legal Counsel was able to research 7 out of the 10 properties listed on respondent's website, and it does not appear that any of them are owned or have been owned by respondent. Thus, it does not appear that respondent falls under a licensing exemption based on the information obtained and within the file. The consent order is the recommendation is a consent order for $2,000 for unlicensed activity in violation of TCA sections 6213-103 and 6213-301. Said order to also include an order to cease and desist all unlicensed activity.
Who wants to make this motion?
So there's 7 or 10?
There's 10 on there. Jenica did the research on the property assessor's website just to print those out and pull them through, and I'm thinking there was an issue with 3 of the properties where you weren't sure you could find them to be sure that this person wasn't the owner of record for those. 7 out of 10 we confirmed that this person was not the owner. The other 3, you had issues with your search, correct?
No, 3 of the properties listed on the website didn't have an actual address.
That's right.
Located with
It was like
so,
area of town. We didn't know.
Yeah.
The audience's benefit, Jenica Smith, who finally opened her mouth up today, is a paralegal, and we're thrilled to have her assistant Julie. We've got a great team with these 2. Okay, who wants
Motion to accept that recommendation, but change the number from 2,000 to 20,000.
Second.
3 that they don't have the addresses for?
They were trying to sell them wherever they were.
Okay.
It's a different property. That's 10.
All right.
It have areas of cities that we do know are in Tennessee at least. So, I mean,
So the motion on the floor is that this particular individual be offered a consent order of $20,000 and to agree to a cease and desist action.
I second that.
Okay, motion by Commissioner McMullen, seconded by Commissioner Bloom. $20,000. Let's vote. Unless there's discussion. All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. Motion passes unanimously. Number 29.
2014029931. Complainant states that she visited a resort associated with respondent in Florida.
Move to dismiss.
Second.
Motion by Commissioner McMullen, seconded by Commissioner Franks, that item number 30, again related to timeshare, be dismissed. Is there discussion? Let's vote. Those in favor of the motion vote aye. Those opposed, no. The motion passes unanimously. 31.
2014029951. Complainant states the complainant wired $5,550 to respondent, an unlicensed individual, in August 2013, with complainant attempting to make a resale purchase of a timeshare owned by other individuals.
To dismiss.
Motion by Commissioner Franks,
Excuse
seconded by Commissioner
me.
McMullen.
It's to close it, right?
It's to close it. This appears to be a scam. I don't even know that this person, our information, we can't get service on them. I'm not even sure that this person is where they say they are, but in any case, they're operating out of Florida. It's not someone within the state, so I can't send anybody to investigate this. It's already been filed with the Attorney General in the state of Florida. So my recommendation is to close it this time because I don't see that there's anything that the commission can take action to do on this if it is in violation.
Then I move to close.
Second.
Motion by Commissioner Franks to accept council's recommendation and close this file, seconded by Commissioner McMullen. Is there discussion? Let's vote. Those in favor of the motion vote aye. Those opposed, no. That motion passes unanimously. Ms. Croft, what else do you have for us today?
That's all. I presented the rest before lunch.
Thank you. Ms. Maxwell, anything new additionally to report?
No, that's all.
We're going, each commissioner, I have a second here. Mr. White, anything from you?
No, Mr. Chair.
Dang you. All right, we're about to finish up here, but don't get up until I tell you to get up, and don't forget to sign out, okay, which is going to have to be an important part of you getting credit. Commissioner Bloom, any last-minute comments?
Oh, but next month we'll not be meeting here. We'll be meeting in my hometown in Bartlett. You're welcome to come.
And where is our meeting going to be?
Bartlett City Hall.
Anything else?
No.
Okay, Mr. Chara?
Just have a happy Easter and drive safe getting out of here. Traffic's a bear.
Ms. Franks?
I'd like to thank everybody for coming, and it really is important that if you see something that needs to be reported to TREC, and especially people who don't have a license, you need to report it so we can take as much care of it as we can.
And Mr. McMullen?
No comment.
Thank you, that's perfect. My only comment is to thank Commissioner Franks for speaking for all of us today when we were coming back from lunch.
When the car almost ran over us.
Oh, I'm sorry. We almost had a head-on, and I
thought she was a good Baptist until then.
I was till then, wasn't I? I was in the front seat with him driving.
Yeah, you ran over us.
All right, guys, thanks for
Sorry.
coming. Please sign out, and please be careful going home.
That's on my official record.